Students are joining. We'll start in a minute. Hello, good morning, and welcome to Byju's Exam Prep. Yesterday, we initiated a discussion on schedules. We looked at Schedule 1 to Schedule 8 of the Constitution. Today, we will discuss Schedule 9 and then Schedule 10. Schedule 11 and 12, I told you, deals with Panchayati Raj institutions and municipalities. And these two schedules we will discuss on Monday, when we will discuss the local government. Today, after the 10th schedule, we will take up a discussion on center-state relations, where we will focus on the legislative relations between center and the states and the administrative relations between center and the state. And then we will talk about this concept of federalism in great detail. Schedule 9 of the Constitution, although we have discussed previously, but let's discuss it again. Ninth schedule of the Constitution, which was inserted into the Constitution because of First Constitutional Amendment Act 1951, when Constitution was amended because there were few judgments that directive principles are inferior, fundamental rights are superior. And that is how Land Reforms Act, Zamindari Abolition Act, which were implemented to try and give shape to directive principles of state policy, to ensure that material resources are distributed for common good, to prevent concentration of wealth in fewer hands. Both these laws were declared unconstitutional because they violate fundamental rights. Then Article 31, capital B, which talks about ninth schedule of the Constitution, was enacted. And basically any law placed in ninth schedule is immune from judicial review. Any law which is placed in ninth schedule, even if it violates fundamental rights under Articles 14, 19, 31, even if it violates any provision of the Constitution, this law cannot be challenged in any court of law because it has been placed in the ninth schedule. And any law which is placed in ninth schedule, there won't be a judicial review. Then came 24th April 1973. What happened on this date? A landmark Keshavananda Bharati judgment was delivered by the court, where Supreme Court said there is something called basic structure, and no amendment of the Constitution can delete those provisions of the Constitution which are part of the basic structure. Then the question arose in Vaman Rao case 1981, in IR Kolo case 2007, and this IR Kolo case was in fact asked in your mains examination as well. In both these cases, the validity of Schedule 9 of the Constitution was challenged. In a sense, if because of Keshavananda Bharati judgment, the Supreme Court has said there is something called basic structure, and judicial review is part of the basic structure of the Constitution. This judicial review, being part of the basic structure, was conveyed by the court in the Minerva Mills case 1980, where for the first time in Minerva Mills case, the Supreme Court is saying judicial review also is part of the basic structure of the Constitution. Then the question arose in Vaman Rao case, in IR Kolo case, what happens to this law which is placed in ninth schedule? Because the Constitution says there shall be no judicial review. And Supreme Court, which is the final interpreter of the Constitution, it says judicial review is part of the basic structure. then what will happen to these laws placed in the 9th schedule? Supreme Court said any law placed in 9th schedule before this Keshavananda Bharati judgment, there will be no judicial review. And any law which is placed in 9th schedule after the Keshavananda Bharati judgment, there shall be judicial review. But even then, this law which is placed in 9th schedule, it gets some protection. Protection in the sense, if there is a law which violates any provision of the Constitution, if it is placed in 9th schedule, judiciary will review it, but judiciary will not strike it down only because it violates the Constitution. It should not violate basic structure of the Constitution. So Constitution is a big book. Only some parts are part of the basic structure. This law which is placed in 9th schedule, it can violate the remaining book, the remaining provisions of the Constitution, but cannot violate those which are part of the basic structure. So now if Parliament wants to give protection to a law, it can place it in the 9th schedule without violating the basic structure, but it can violate other provisions of the Constitution. Sir, can you give an example? I'll give you an example. Andhra Pradesh, Telangana, Madhya Pradesh, Maharashtra, what are they trying to do? They are trying to give more reservation to OBCs. When they give more reservation to OBCs, that means they want to bring in more caste groups into this group called OBC, and which thereby violates the 50% limit which was imposed by the Supreme Court in the Indira Sani case. That reservation cannot at any point exceed beyond 50%. Now imagine a situation if these laws passed by various states, because a state law can also be placed in 9th schedule. It's not only parliamentary law, state law can also be placed in 9th schedule. Can you give me an example where a state law was placed in 9th schedule? Kerala Land Reforms Act. And in fact, Keshavananda Bharati case was primarily about when Keshavananda Bharati challenged the decision of the Kerala government to get this law, Kerala Land Reforms Act, placed in 9th schedule. Does this violate Constitution or not? That means even a state law can be placed in 9th schedule. Even a parliamentary law can be placed in 9th schedule. But who can place this law in the 9th schedule? The parliament, the central government. If this law is placed in 9th schedule, it can also violate this 50% cap imposed by the Supreme Court. Why? Because 50% cap is not part of the basic structure yet. If tomorrow Supreme Court says even this 50% limit is part of the basic structure, then these laws will be declared unconstitutional. But since 50% cap on reservation is still not part of the basic structure, which means this state law which gives reservation to OBCs, because of which reservation percentage increases beyond 50%, even this law, if it is placed in 9th schedule, it gets protected. Because it is violating Supreme Court judgment, it is violating provisions of the Constitution, but it is not violating the basic structure of the Constitution. And that is how in IR Kolo case, the Tamil Nadu reservation law, which was placed in 9th schedule, was challenged. Although this challenge is heard by the court even today, but it still has protection because this law is placed in 9th schedule. Long story short, 9th schedule of the Constitution. Any law which is placed in 9th schedule, originally there will be no judicial review. Laws were placed, then came 24th April 1973. Supreme Court said that there is something called basic structure. Continued, we reached 1980. Minerva Mills case, Supreme Court said judicial review is also part of the basic structure. Then the question arose in Vaman Rao, 1 year later in 1981. Then in IR Kolo case, 2007. What will happen to this law which is placed in 9th schedule? Because you say there is no judicial review, but Supreme Court says judicial review is part of the basic structure. Then the Supreme Court said, when was this judicial basic structure doctrine innovated? 24th April 1973. Laws placed before this date are immune from judicial review. We will not question these laws. Laws placed after 24th April 1973, there shall be judicial review. There can be judicial review. There may be judicial review. But this law can violate any provision of the Constitution except the basic structure. Basic structure at any point in time cannot be violated. That is Schedule 9 of the Constitution. Okay. Now let's look at 10th schedule of the Constitution, which deals with anti-defection law. Which means legislators, whether you are from Lok Sabha or Rajya Sabha, Legislative Assembly or Legislative Council, this legislator can be disqualified on the grounds of defection under anti-defection law, which is part of Schedule 10 of the Constitution. But how? We looked at that there are certain qualifications in order to become the member of the legislature. You should be the citizen. You must have completed certain number of years of age. You should also not be holding office of profit. But once you are qualified, then you are elected. Even after your election, you should not come under disqualification. What are the grounds on the basis of which a legislator can be disqualified from the House? Mental unsoundness, change in the nature of citizenship, if you are adjudged insolvent, if you are holding an office of profit. And the fifth provision is any other law passed by the Parliament, which means Parliament can prescribe more disqualifications on the basis of which you will be disqualified from the legislature. That means more grounds of disqualifications can be prescribed by whom? By the Parliament. And Parliament has done that. Parliament has enacted two important laws which deals with disqualification. One is the Representation of the People Act 1951, which we will discuss in elections. And the other is anti-defection law, which is part of the 10th schedule of the Constitution, which was enacted 52nd Constitutional Amendment Act 1985. Rajiv Gandhi was the Prime Minister. And now legislators can be disqualified on the grounds of defection. But what is a defection? Let's say, for example, this is a state X. It has 100 seats. Clear? This is a state X. It has a legislative assembly. It has 100 seats. Now, there are principally two political parties which are contesting elections. And political party A bags 55 seats. And political party B bags 45 seats. Who do you think is able to form the government? A is forming the government. Why? Because A has the majority on the floor of the Legislative Assembly. Because that is what parliamentary democracy is. Council of Ministers, headed by the Chief Minister, they will hold office as long as they enjoy the majority in the Legislative Assembly, in the Lok Sabha. Clear? Now, I am also part of this political party B. Now, what happens when I am part of this political party B? I have a lot of cash as well. What do? I bribe the MLAs of A. Take this money, bag full of cash. I will also give you a post. I will make you a finance minister. I will make you a home minister. I will make you minister of an important group. You come, but along with you, bring others as well. All of them will be given cash, bag full of cash. Now what happens? 10 of these MLAs, they resign. When they resign, they join party B. They are still MLAs. They are not disqualified. They only change their ship. They only jump the ship. They only cross the floor. Floor in the sense, if this is Legislative Assembly, on one side are the members of the government sitting, on the other side are the members of the opposition sitting. This is the floor. Now, some members of the opposition, they resign, they cross the floor and they reach this part of the legislature. That's what we call defection, crossing the floor, party hopping. That means from one political party to another political party. What will happen in the state? This political party A has now lost the power. Why? Because they had 55 seats. Now they have only 45 seats. When they have only 45 seats, political party B has now 55 seats. I become the chief minister. But there are other members of my political party. There are other legislators who are now approached by party A. You now join us. And some of these now 10 MLAs, they resign from B, join A. So it's like a musical chair. One set of MLAs joining A, after some time joining B, after some time joining A again. And this musical chair leads to what? Instability in the government. That means we don't know for how long this government will continue, because this government, instead of focusing on governance, will focus on how do I keep my flock together? How do I keep my MLAs together? Because at any point in time, they can jump the ship and join another political party. This leads to instability, and it also leads to one form of corruption. Corruption in the sense, imagine a situation, which is a real situation. Almost all the MPs belonging to the BJP right now in Lok Sabha, why are they elected? Primarily, they're elected by the people because they represent Mr. Modi. So it's like during the Congress rule, during Indira Gandhi's term, it was alleged that even if a lantern is set up as a candidate by the Congress, people will vote for that lantern, because people don't vote for an individual, they vote for the party. And these MPs belonging to the BJP, 303 MPs belonging to the BJP in Lok Sabha, most of them have got elected. Even if people don't know about them, they have got elected because they represent Mr. Modi, they represent the party, the BJP. So people vote for BJP, not necessarily for an individual candidate. And now these 55 MLAs, they were elected to the state legislative assembly by the people because they belong to a political party A, because they associate themselves with the ideology of the political party A, with the policies and the programs of this political party A. Now, if they jump the ship, then join party B, ideally they should be disqualified. Why? Because I elected you because you represented party A. Now, if you are joining party B, I should again get to decide whether I will support you or not, whether I will elect you or not. So ideal situation should have been, if you resign from MLA, you should also resign from your party and then join another political party and then contest elections again. The curious case was of Gayalal. In 1967, elections to Haryana happened for the first time, because that's when Haryana got separated from Punjab. Punjab was bifurcated into Punjab and Haryana. 1967, the first elections was conducted to the Legislative Assembly of Haryana. Gayalal, he was an independent member. Independent member in the sense, he was not set up by any political party. For example, tomorrow I want to contest elections. I approach the BJP, give me ticket, I want to contest from Amethi. BJP says, no, we will give this ticket to Shrimati Irani. I approach Congress. They say, no, Rahul Baba will contest the election. I approach Samajwadi Party. They're not giving me the ticket. Now, what do? I contest the election as an independent candidate without the ticket of any political party. Gayalal was same independent candidate, won the election, got elected to the Legislative Assembly of Haryana. And he changed his political party 3 times in a single day, and then 4 times in a fortnight. So in the morning, he was an independent. Then he joined the Congress party. Then he joined the United Front. After 15 days, he joined the Congress party again. Then he resigned from the Congress and became part of the United Front again. What is this? Is this a musical chair? One member, Rao Birendra Singh, he was the head of the Congress party at that time in Chandigarh. He called a press conference. Next to him was Gayalal. The media asked question to Rao Birendra Singh, whose side is Gayalal on? Because initially he was an independent, then joined Congress, then United Front, then Congress again, then United Front again. Whose side is Gayalal on? Because he changes his party like the way we change our clothes. Rao Birendra Singh said, Aya Ram, Gaya Ram is now Aya Ram. He had left, but now he has come back. So this Aya Ram, Gaya Ram, is basically a phrase which is used to define these defections. Today you are in one political party, then you join another political party, then you come back, then you join another political party. This leads to instability of the governments. And it is this defection which has led to the fall of more than 50 state governments since the independence of India. Same happened in Haryana again, 10 years later. Bhajan Lal, along with all his MLAs, he joined Indira Gandhi's Congress. Is this a joke with the people of India? We elected you because you said that you are against Indira Gandhi. Now you have joined Indira Gandhi. Tomorrow we will elect you because you are part of Indira Gandhi. But then you will join another political party. Is this a joke that you are making to the people of this country? And to curb this defection, we needed a law. And that law was passed when in 1985, Constitution was amended. 52nd Constitutional Amendment Act was passed. The year was 1985. 10th schedule was added to the Constitution. This was the need to bring in this law. When you know the need, let's look at the provisions. What are the provisions? Provision number 1. If I am a member of a house, now listen to me carefully, I am a member of a house, because we are talking about disqualification. Who can be disqualified? Somebody who is a member of a house. House can be Lok Sabha, Rajya Sabha, Legislative Assembly, Legislative Council. If I am a member of a political party, I am a member of a house as well. That means I am a member of a house belonging to a political party. If I voluntarily resign from that party, I will be disqualified. That means if I am from BJP right now, I am also elected to Lok Sabha. If I resign from the BJP, I will be disqualified under anti-defection law. Disqualified. That means you are no longer the member of the parliament. That's provision number 1. Provision number 2, if you violate the whip, and we have discussed in parliament, what are these 3 types of whips? 1-line whip, 2-line whip, 3-line whip. For example, do you know that Supreme Court, when it hears a constitutional case, when a constitution bench is hearing a particular case, constitution benches, 5 judges are hearing a particular case, the Supreme Court streams the proceedings of this case live. Are you aware of it? No, yes. So you should sometimes, if you have time, for example, you're having breakfast or you're having lunch, you should take a look at these proceedings. Brilliant proceedings. And this is how you will also learn law. Just, it won't be of much significance for your exam, but at least you will have an idea of how the cases are pleaded before the court. Beautiful. And this case is right now in the court as well. On one side, we have Kapil Sibal and Abhishek Manu Singhvi. On the other side, we have Mahesh Jethmalani. And they are debating this anti-defection law before a constitution bench of the Supreme Court headed by Justice Chandrachud. Brilliant arguments. The point is, when a whip has been issued, which is a 3-line whip, the whip has been issued in the sense, I belong to the Congress. Now, Citizenship Amendment Bill is to be voted upon. I get a whip from my political party that you have to come in the Lok Sabha, that's line 1. Number 2, you have to participate in the proceedings. You have to vote. Line number 2. Line number 3 is you have to vote against this bill. If I vote contrary to this whip can be if I vote in favor of this bill or if I abstain. Whip is telling me vote against, but I'm doing something contrary. I am voting in favor or I'm abstaining. I will be disqualified under anti-defection law. But there is an exception. What is the exception? For example, Citizenship Amendment Bill is being debated in the Lok Sabha. Whip has been issued by the Congress party to all its MPs that you have to vote against this bill. Rahul Gandhi is also a member of the Lok Sabha belonging to the Congress. Now, Rahul Gandhi mistakenly makes mistakes. Mistakenly votes in favor of the Citizenship Amendment Bill. Should be disqualified. But how will we disqualify Rahul Gandhi? The members of the Congress party will ask, what have you done? I said, I don't know. I didn't get proper sleep. I thought you said vote in favor. I could not understand. So now I've voted in favor. Now what do we do? The speaker will disqualify you. There is an exception. The exception is within 15 days, if you have violated the whip of the political party, which means you're voting contrary to the whip issued by the political party. If the political party wants, it can take a decision within 15 days condoning your violation, accepting your violation. That means I have no problem as a political party if Rahul Gandhi has violated the whip. If I condone your violation, then no action will be taken against you. You will not be disqualified. But if after 15 days, the political party has not condoned your violation, has not in written said, we agree with your violation, then you will be disqualified under anti-defection law for violating the whip issued by the political party. So what is anti-defection law? It was passed in 1985 by amending the constitution by adding 10th schedule of the constitution. What was the purpose? The purpose was to prevent these immoral defections, party hopping, ayaram, gayaram. To prevent them, what are the provisions? Provision number 1, if a member of a house belonging to a political party voluntarily resigns from that party, disqualified. That's why I said, listen to me carefully, a member of a house belonging to a political party. Now you might say, sir, what happened with Jyotiraditya Scindia? He was from the BJP, he was from the Congress. He resigned from the Congress and he joined the BJP. Why was he not disqualified? Can anybody tell me the answer? Exactly. Because when Jyotiraditya Scindia resigned from the Congress, joined the BJP, he was not a member of any house. He was neither an MP nor an MLA. When he was neither an MP nor an MLA, from where do we disqualify him? Because he is not a member of a house. If he is a member of a house belonging to a political party, if you then voluntarily resign from your party, you will be disqualified. Provision number 1. Provision number 2, if you are a member of a house belonging to a political party and you vote against the whip or you vote contrary to the whip issued by the political party, disqualified. But there is an exception. If political party wants, within 15 days, it can condone your violation. If it doesn't, then you will be disqualified under anti-defection law. Now another provision. An elected member of a house who has been elected as such other than as a candidate set up by any political party. What does that mean? There is an independent member of a house. Independent member, I contested election from Amethi, but no political party gave me the ticket. I defeated Rahul Baba as well as Smriti Irani. Now I am an independent member of the Lok Sabha. Independent. I do not belong to any political party. After my election, if I join any political party, I will be disqualified under anti-defection law. People voted for me because they thought I will represent an independent voice in the Lok Sabha. They rejected both the predominant political parties, the BJP and the Congress. Now, if they have elected me, an independent member of a house, and then if I join the political party, any political party after the election, I will be disqualified. This is again where you will have a confusion. So there are some independent members who are elected to a house. They're also made ministers. Why are they not disqualified? Can anybody tell me the answer? An independent member belonging to house can be Lok Sabha, Rajya Sabha, Legislative Assembly, Legislative Council, they're also made ministers. How is that possible? Why are they not disqualified under anti-defection law? Because they don't join a political party. They join government. Government. And what is the difference? For example, we have a government in Maharashtra, which is Shiv Sena plus BJP government in Maharashtra. Does that mean all the members of the BJP should be disqualified? No. Does that mean all the members of the Shiv Sena should be disqualified? No. Why? Because it's like a coalition government. Coalition government in the sense the government will have multiple political parties. So you can say this independent member is an independent political party. Although it's not an independent political party, it's an independent voice. So this independent member can join the government, can become a minister. But if this independent member joins a political party, disqualified under anti-defection law. And the fourth one is, we have a nominated MP. Who is a nominated MP? Somebody who is nominated to Rajya Sabha. Somebody who is nominated to Legislative Council. If you are a nominated member of a house, you have 6 months. Within 6 months, you decide which political party you want to join. But if you join a political party after 6 months of your nomination, you will be disqualified under anti-defection law. I belong to a category of individuals who have made brilliant contributions in the field of art, literature, science, social service. So I am completely detached political figure. I know nothing about the politics. But since I am an expert, the president nominated me to Rajya Sabha. Now the House of the Parliament, listen to me carefully, House of the Parliament shall meet as often as possible, but in such a manner that the time between the first and the second session should not be more than 6 months. So now when I'm nominated as the member of the Rajya Sabha, now I have 6 months to analyze which political party is doing good, how are they debating, what sort of topics do they debate. And if I get fascinated by one political party, I will join that political party within 6 months. But within 6 months of the nomination, if I join a political party, I will not be disqualified. But if I join a political party 6 months after my nomination, I will be disqualified under anti-defection law. Clear? But this disqualification on the ground of defection will not apply in case of merger. What is the merger? You will have a lot of questions right now on anti-defection law. I will urge you, stay calm. Don't ask any question right now, because I'm 100% sure once I end this topic, you will have no doubt whatsoever on your mind. So listen to me calmly, patiently, make note of whatever I'm writing. Just listen to me, don't ask any questions, because automatically you will find answers to all your doubts and questions. Listen to me carefully. Now, this is a political party. Previously, there was a provision of 1/3 split. What is the 1/3 split? There is a political party which has 30 MLAs belonging to a political party A. Originally, anti-defection law said if 1/3 of these MLAs, which means 10 MLAs, if they want, they can split. That means they can come out of that political party and they can form another political party. And then these 1/3 MLAs will not be disqualified. Because these 1/3 MLAs, they are member of a house belonging to a political party, because this political party gave them ticket to contest the election. They won the election. Now these 1/3 MLAs, if they resign, they should have been disqualified under anti-defection law. Because any member of a house belonging to a political party, if you voluntarily resign from that political party, you will be disqualified. Clear? But the exception was made that there can be a split in a political party. That if there is a political party with 30 MLAs, if 1/3 of these MLAs decide to split the political party, come out of that political party, form a different political party, then these 1/3 MLAs will not be disqualified under anti-defection law. But thanks to Mr. Atal Bihari Vajpayee, 91st Constitutional Amendment Act was passed. This 1/3 split was repealed. This 1/3 split of a political party is no longer valid now. That means even if 1/3 MLAs belonging to a political party, if they voluntarily resign from that party, split from that party, form a different political party, they will not be disqualified. This exception was done away with, repealed because of 91st Constitutional Amendment Act. But there is an exception. What is the exception? Disqualification on the grounds of defection will not apply in case of merger. And what is this merger? Listen to me carefully. This is a political party. This political party has an organization. This political party has a legislative wing. Clear? What is the difference between organizational wing and the legislative wing? For example, we have the BJP. BJP has office bearers as well. President of the party, vice president, general secretaries, office bearers, district members, so on and so forth. So as an organization, we have the BJP. But not all members of the organization, they are part of the house. They are part of the Lok Sabha or Rajya Sabha or Legislative Assembly or Legislative Council. So there is a difference. There is one organizational wing and then there is a legislative wing. Anti-defection law says if this political party wants to merge with another political party. Now, for example, we have the JDU, Janata Dal United, led by Nitish Kumar. And there are talks that maybe Janata Dal United will merge with the Rashtriya Janata Dal led by Tejasvi Yadav. Will it happen? Will it not happen? We don't know. Let's imagine a situation. If Janata Dal United as a political party merges with Rashtriya Janata Dal, what will happen to the MLAs, to the legislators of this RJD or JDU? What will happen to them? Will they be disqualified? No. They will not be disqualified. Why? Because the political party has merged with another political party. But this merger of one political party with another political party should be supported by 2/3 members of their legislative wing. Sir, what does that mean? If JDU decides to merge with the RJD, that means these two political parties are now merged. When they are merged, let's say the new name is Rashtriya Janata Dal. So there is no change for MLAs belonging to RJD. They continue to be part of the RJD. But now there is a change. All the office bearers who are part of the organization wing of JDU, they now become part of the RJD. Is this allowed? Yes, political parties can merge. We have seen merger of political parties. For example, Janata Party led by Dr. Subramaniam Swamy merged with the BJP. It's allowed. It's okay. Possible. Done. But this merger, what will happen to these MLAs, to the legislators of JDU? If 2/3 of their legislative wing, if 2/3 of their MLAs belonging to a house, if 2/3 of their MPs belonging to the parliament, if they agree with this merger, they will not be disqualified. And what will happen, sir, to the remaining 1/3? They may create a separate political party. They may act as an independent. Nothing will happen to them. But if these 2/3 members now, they are now part of the RJD because their political party has merged with the RJD, they will not be disqualified. But on this, if you have confusion, I also have confusion. Supreme Court also has the confusion. And that is why this confusion is being heard by the Supreme Court right now. What is this confusion? Political party, as I said, has two wings. Organizational wing and the legislative wing. When we say this disqualification on the grounds of defection will not apply to merger, is this merger only of the legislative wing or the organizational wing as well? Does that mean that those who are part of the JDU's organization, majority of them should decide first that we will merge with the RJD? That means organizationally, the two political parties are merging. But will this merger be good, bad, ugly, beautiful? That should be supported by the legislative wing. So it cannot be that only legislative wing decides to merge with another political party. And at the same time, for example, Shiv Sena. Shiv Sena in the sense, it had 55 MLAs in the Legislative Assembly of Maharashtra. 40 MLAs. They claim that we are the real Shiv Sena. 15 MLAs. They claim that we are the real Shiv Sena. Election Commission has the power to decide on this dispute which faction is the real Shiv Sena, which faction will get the name Shiv Sena, which faction will get the symbol, bow and the arrow of the Shiv Sena. And the Election Commission said these 40 MLAs, they are the Shiv Sena. But ideally, this cannot be allowed. Ideally, according to the law, this cannot be allowed. Why? Because if you want to split a political party, this split is not allowed. This split is not allowed. 1/3 of political party, 1/3 of the legislative wing, resigning from your party, forming another political party. This was done away with 91st Amendment. It's not possible now. So whether it is 1/3, whether it is 2/3, whether it is 3/3, whatever it is not allowed. And at the same time, now the Supreme Court will look at this, that if, for example, these 40 MLAs decide to merge with the BJP, will that be allowed or not? Imagine a situation that Shinde group, all these 40 MLAs, they decide to merge with the BJP. Is this allowed or not allowed? Will these 40 MLAs be disqualified for violating anti-defection law or not? There is confusion on this provision. Why? Because merger would be if political parties have merged, which basically means, look at me carefully. If the Shiv Sena as a political party merges with the BJP, that means ideally organization of the Shiv Sena should have to merge with the BJP. And this merger should be supported by 2/3 of the legislative wing of Shiv Sena. Then this group, Shiv Sena group, will be merged with the BJP. Then they will not be disqualified. But split is not allowed. And what has happened in Maharashtra is a split, which is not allowed. What has happened in Maharashtra is that the split of the legislative wing. Organizationally, we don't know who gets the majority. So the exception is creating confusion, and that is why the court is hearing this matter. But what is the confusion? Long story short of it, when you voluntarily resign from your party, if you are a member of a house, you are disqualified. Initially, the position was if there is a split in a political party. For example, if this is the legislative wing and 1/3 MLAs or 1/3 MPs of this wing, they decide to resign en masse, that means together they decide to resign, they will not be disqualified. That means they have engineered a split in the political party. But this provision was repealed by 91st Amendment. Split is no longer allowed by anti-defection law. That means if there is a split, you will be disqualified. But then another exception is disqualification on the grounds of defection will not apply in case of a merger. But is this the merger of only the legislative wing, or is this merger of the organizational wing as well? On that, we don't have a clarity. That's why the court is hearing this matter. And the point here is, ideally, it should be the organizational and legislative wing put together. They should merge with another political party. And once two organizations decide to merge together, this merger should be supported by 2/3 of their legislative wing. If 2/3 of their legislative wing accept this merger, then these 2/3 legislators will not be disqualified under anti-defection law. And what will happen to the remaining 1/3? They may form a separate party, they may act as a different political unit, nothing will happen to them as well. That is the exception. Another exception, for example, Speaker, Deputy Speaker, Deputy Chairman of Rajya Sabha, Chairman of the Legislative Council, Deputy Chairman of the Legislative Council. Who are these individuals? They're basically members of the House. Mr. Om Birla is the member of a House, Lok Sabha, belonging to the BJP. Mr. Om Birla contested re-election for the post of the Speaker. He got the simple majority in Lok Sabha and now is sitting on the chair of the Speaker. But as a Speaker, I am the conscience keeper of Lok Sabha. As a Speaker, I belong to everybody, not the BJP, all the members of the House. I have to appear impartial as well. I can't appear partial. I can't favor my political party as against the opposition because I'm the Speaker of Lok Sabha. I'm not the Speaker of the BJP. If I want, I can resign from the BJP and I will not be disqualified. If I'm the speaker, member of a political party, elected to Lok Sabha, ideally, if you resign from your political party, you will be disqualified. But if you are elected to the post of the speaker, then because of this election, you want to resign from the BJP, you will not be disqualified. Why? Because there is an exception. Why this exception? Because now I am Om Birla. I want to appear impartial. I don't want to appear supporting one political party as against the other. I'm not the speaker of the BJP. I'm the speaker of the Lok Sabha. I resign from the BJP so that now Rahul Baba cannot say that I belong to the BJP. I'm supporting the BJP. I belong to everybody who is part of Lok Sabha. Which means I am voluntarily resigning from BJP, which gave me the ticket to contest the election, but I will not be disqualified. Why? Because there is an exception. What if, for example, after 3 years, I am removed as the speaker or I resign as the speaker? Now, what is my status? Do I belong to any political party or not? I have to join the BJP again. If after my removal, if after my resignation from the speaker, I'm not resigning from the house, I'm resigning from the post of the speaker. I have not been removed from the house. I have been removed from the post of the speaker. If after my removal or after my resignation, what is my status? I have to join the BJP again because that's the party which gave me the ticket to be in this house. But if after my removal, after my resignation, I join Congress or any other political party other than the BJP, I will be disqualified under anti-defection law. That's another exception. But who will take this decision? This decision will be taken by the Speaker, Speaker of Legislative Assembly, Speaker of Lok Sabha, Chairperson of Legislative Council, Chairperson of Rajya Sabha. If the Speaker or Chairperson are absent, or if the Chairperson's post is vacant, if Speaker's post is vacant, then who will take that decision? Deputy Speaker or Deputy Chairperson. For example, in case of Maharashtra, when this Maharashtra political crisis started, there was no speaker in the Maharashtra Legislative Assembly. When there was no speaker in the Maharashtra Legislative Assembly, who will then decide on these disqualification petitions? Who will disqualify somebody if you have been found violating anti-defection law? That decision will be taken by the Deputy Speaker. Which means, if a member of a house is to be disqualified on the grounds of holding office of profit, or if there is change in the nature of citizenship, or if you have been declared adjudged and insolvent, or if there is a change in the nature of citizenship or mental unsoundness, who will take that decision? President will disqualify you if you are a member of the parliament. Governor will disqualify you if you are a member of the state legislature. But president and the governor cannot disqualify you on their own. They have to refer this matter to Election Commission of India. And whatever report is given by Election Commission of India, that is binding on the president and the governor. Which means if Election Commission says disqualify them, you will be disqualified. If Election Commission says don't disqualify them, you will not be disqualified. But when it comes to disqualification on the grounds of defection, under anti-defection law, under 10th schedule of the Constitution, who will disqualify you? Speaker of Lok Sabha, Speaker of Legislative Assembly. If this post is vacant, then Deputy Speaker of the Lok Sabha, Deputy Speaker of the Legislative Assembly. Similarly, Chairperson of Rajya Sabha, Chairperson of the Legislative Council. If this post is vacant, Deputy Chairperson and the Deputy Chairperson of the Rajya Sabha. If these posts are also vacant, then somebody will be appointed by the Lok Sabha, by the Legislative Assembly to decide on this question. But what if there is a question that the speaker himself is subject to disqualification? There is a question that chairperson himself is subject to disqualification. I am asking you a question. The chairperson of Rajya Sabha can be disqualified under anti-defection law. Is this statement correct or incorrect? I repeat, the chairperson of Rajya Sabha can be disqualified on the grounds of anti-defection law. Correct? Incorrect? Majority are right, because this is incorrect. Why? Because you can be disqualified from being the member of a house under anti-defection law. Is the chairperson of Rajya Sabha member of a house? No. He is the ex-officio chairperson of Rajya Sabha, the Vice President of India. He is not the member of the house. So this Vice President of India cannot be disqualified on the grounds of anti-defection law, on the grounds of defection. But chairperson of Legislative Council can be. Why? Because he is elected by the members of the Legislative Council. He is member of a house. Now imagine a situation where we say the chairperson should be disqualified, where we say the speaker should be disqualified. Who will take that decision? This decision will be referred to such member of the house as the house may elect in this behalf. Which means, Mr. Om Birla, you should be disqualified under anti-defection law. Why? Because you were given ticket by the BJP. After you were elected as the speaker, you joined the Congress. You can resign and not be the member of any political party. You will not be disqualified. But you cannot join any political party. If you join Congress, which means you have violated anti-defection law, you should be disqualified. Now, who will take that decision? Lok Sabha will elect one MP from Lok Sabha. You decide. You have only one objective. You decide whether speaker should be disqualified or not. And the original anti-defection law said, decision of the speaker shall be final and binding. An original anti-defection law passed in 1985 said, there will be no judicial review. Because Parliament thought that this is a matter which deals with legislature. And there is separation of powers between judiciary and the legislature. And we as a legislature will decide whether you should be disqualified or not. Supreme Court, please stay away from this. Don't interfere in this matter. The decision of the speaker shall be final and binding. Matter went to the court. Kyoto Holoho versus Zachilhu, 1992. Supreme Court said anti-defection law is constitutional. We have no problems with anti-defection law. But we have a problem when you say speaker's decision shall be final and binding. We have a problem when you say there shall be no judicial review. How can you say there is no judicial review? Judicial review is part of the basic structure of the Constitution. Any law which violates basic structure, that provision is unconstitutional. And this provision, where you say the decision of the speaker shall be final and binding, that there is no judicial review, this is unconstitutional. Why? Because it can be reviewed by the judiciary, because judicial review is part of the basic structure of the Constitution. But in this case, something else was argued. What was argued? You are creating supporting political parties as an entity rather than supporting the independence of legislators. And their freedom of speech and expression. My lord, anti-defection law is unconstitutional. Why? Because look at the powers, privileges and immunities available to the members of the parliament. Sir, what are these powers, privileges and immunities? I can say whatever I have to say inside parliament, inside legislature. I can vote whichever way I want to vote inside the parliament. And whatever I say, whatever I vote and how I vote will not be questioned in any court of law. So how can you say if you violate the whip, if you vote against the whip, you are disqualified? This is unconstitutional. It violates my freedom of speech and expression, which is absolute inside the parliament. Court said you are raising a technical issue. If you are raising a technical issue, I will give you a technical answer. What is that technical answer? Your privilege is, listen to me carefully, your privilege is no matter what you say and how you vote, you cannot be held accountable in any court of law. Are we as a judiciary punishing you because you have voted against the whip? We have not. It is your own house which is disqualifying you. It is your own political party which says you should be disqualified. So we are not involved at all. Why? Because your privilege is, no matter what you say, how you vote, you will not be held accountable in any court of law. Your decision cannot be inquired into any court of law. So in court of law, we are not punishing you for how you are voting. We are not disqualifying you. It is your own house which is disqualifying you. That is the technical answer to your question. But we will discuss this separately as well. You're raising a fundamental question. That in a political party, and because of these political parties, we have democracy. But these political parties are made up of the representatives. I am elected by the people to Lok Sabha. And there I have to take up the grievances of my people. There I have to discuss the problems being faced by the people of my constituency. And there I should have the freedom of speech. Freedom of speech in the sense, let's say I come from a constituency which is dominated by the farmers. And farmers are against the 3 farm bills. But I belong to the BJP. I know my people of my constituency are against the 3 farm laws. But this bill which is presented in the Lok Sabha, BJP issues a whip that you have to vote in favor of this bill. I am helpless. I know my people, my constituency, they don't want me to vote in favor of this bill. But this whip is binding on me. I have to vote in favor of this bill. Then, my lord, where is my freedom of speech? How can I represent the people of my constituency? The court was told that, dear court, this is how democracy functions. We have to empower political parties as against the individual legislators. Because who are these legislators? They are elected on the policies and the programs of a political party. So whatever political party decides, that is binding on them. The Supreme Court said, yes, we agree. Yes, we also agree that in this case, if this whip is not binding on you, then it will lead to the same problem as happened previously. There will be instability in the governments. Sir, how instability of the government? Because the first example that I gave you, these 55 MLAs, what if Party B is introducing a no confidence motion? Clear? This no confidence motion should be passed by simple majority. Basically, the idea is that we have to ensure the stability of the government. Party A, if there is no whip, Party A's MLAs, they will have to ideally vote for Party A, vote for their chief minister. Party B will vote against the chief minister. Clear? Now imagine a situation, if there is no whip, then what will happen to these 10 MLAs? They will not vote for their chief minister, they will vote against the chief minister. Then what will happen in this case? The government will fall. That's what used to happen prior to anti-defection law. If the same thing happened now as well, then what is the point in having anti-defection law? Because there will be instability if there is no whip. So whip should be binding on the legislators, because if the whip is not binding, then what will happen? The instability of the governments will increase. Because then the opposition will have a collusion with the members, some members of the ruling political party will bribe them that you vote against them. When you're voting against them, the government falls. When the government falls, this political party is now able to form the government. So this musical chair will continue if this whip is not binding. So whip is binding. There is nothing unconstitutional there. Because we imagine politics in the form of political parties. And political parties have given you the ticket. So when political parties have given you the ticket, on the ticket of the political party, you have been elected to Lok Sabha. So in Lok Sabha, you have to obey what the political party tells you to do. And that is why we have a whip. In fact, it was explained to the court what is the need for whip. In the sense, we have 30 MPs of this political party A. All the 30 MPs are in different constituencies. Now, I'm taking care of my constituency, I'm meeting people there. You are taking care of your constituency, you are meeting there. How would we know that there is going to be a session of Indian Parliament? For that, there is a whip who will inform us that, oh, come here, there is a session of Indian Parliament. So my party leader, the political party which gave you the ticket, wants you to be part of the parliament and discuss the proceedings. But foreign policy, for example, I am a representative of a far-flung constituency where people are struggling for water, sanitation, education, health. I have no idea about foreign policy. So there is a foreign policy debate going on. What should be my position on this foreign policy matter? I don't know. Whip will be issued. The party will tell me this is going to be your position. So you have to speak in the parliament and you have to speak against China. You have to speak in the parliament and you have to justify why we took a different position on Russia-Ukraine war. Because individual MPs cannot have their own independent foreign policy programs, objective, idea. The whip has to tell me, the political party has to tell me, this is our stand. And that is why anti-defection law, if it creates political parties as powerful entities, it is not unconstitutional, because that's how democracy functions. Long story short, in Kyoto Holoha, the validity, the constitutional validity of anti-defection law was challenged on various grounds. One such ground, that it violates basic structure, which is judicial review. The Supreme Court said, yes, you are absolutely right. Judicial review is part of the basic structure of the Constitution. Any law, if it violates judicial review, is unconstitutional. So Speaker will take the decision, but the decision of the Speaker is not final and binding. We will have the power to review that decision. But if you're saying whip should not be binding, it violates the freedom of speech and expression of the individual legislators. We don't agree with that, because we have been constructively proven. It has been proved before us that it is the political parties which decide who to give ticket, and once you have been given the ticket, you have to abide by the whip of the political party. But then the question was, who can complain? Who can complain in the sense? A curious case happened in Odisha, 2013. There were 4 MLAs elected to Odisha Legislative Assembly from NCP, Nationalist Congress Party, belonging to Sharad Pawar. And all these 4 MLAs, they joined the Biju Janata Dal led by Biju Patnaik, the Naveen Patnaik. Naveen Patnaik was the chief minister. Now, the president of the Nationalist Congress Party in Odisha approached the speaker, please disqualify them. Said, why should I disqualify them? Because they have resigned from their political party and they have joined your political party. But there is something called merger. 2/3 members, if more than 2/3 members, they want to merge with another political party, they will not be disqualified. NCP said, but for that, there should be first merger of NCP with the BJD. Then this merger should be supported by 2/3 of the members of the Legislative Assembly belonging to the NCP. That's how merger can take place. Speaker said, yes, there is some confusion here. The law is not clear. What do I do? Speaker did not act at all. Speaker said, who are you? Said, I am the president of the Nationalist Congress Party in Odisha. But you can't complain. You can't file a petition before me asking that somebody should be disqualified under anti-defection law. Said, why? Why can't I complain? Because you are not a legislator. When you are not a legislator, you have no locus standi. What does that mean? It means that we have rules. Under anti-defection law, we have made rules. And in these rules, we talk about who can complain. So if there are these 4 NCP MLAs in Odisha Legislative Assembly who should be disqualified under anti-defection law, this petition can be filed only by a legislator. So if there is a legislator belonging to Odisha Legislative Assembly, if one of them approaches me that disqualify these 4 MLAs, I will take the decision. But who can complain? Only a legislator. You You are not the member of the Legislative Assembly, Mr. Parida. You are the president of the Nationalist Congress Party in Odisha, but you're not a legislator. And according to rules, only the legislator can complain. Gentlemen approached the court. My lord, who can complain? Speaker, Odisha Legislative Assembly versus Utkal Keshri Parida, 2013. The Supreme Court said any voter can complain. Any voter. This rule, which says only a legislator has the locus standi to file a complaint. No, we don't agree with this rule. This is unconstitutional. Null, void. Anybody can complain. Even if you're a voter, you can approach the speaker. Speaker, this person should be disqualified for violating anti-defection law. Take the decision. So any voter can complain. So this rule, which originally talked about that only a legislator can complain before the speaker, this is unconstitutional. Any voter can complain. But thanks to Atal Bihari Vajpayee, one more change was made to this anti-defection law. Change number one was this 1/3 split is no longer valid. 1/3 members of a political party, if they want to split from their political party, and then they will not be disqualified. This exemption was done away with. This was repealed by 91st Amendment. But something else was happening, which was violating the spirit of anti-defection law. What is that spirit? I belong to the BJP, but BJP lost the elections. Now it's the Congress government which is in power in my state. What do? I want power because I'm not happy only being a legislator. I want power as well. I'm resigning. When I'm resigning, why should I resign? I'm resigning because I have a lure of power. What is that lure of power? I am appointed a minister by the Congress government, or I'm appointed as the head of State's Human Rights Commission. Not State's Human Rights Commission, for that you should be a judge. Let's say if I'm appointed a member of a statutory body, I'm appointed a member of any important organization. That means I'm appointed to a post which is known as the remunerative political post. A remunerative political post is one for which the salary is paid from the public money, from the public revenue. 91st Amendment said a defector. Who is the defector? If I am from the BJP, I voluntarily resign from the BJP, which means I'm disqualified under anti-defection law, which means I'm a defector. When I'm a defector, I cannot be appointed to any remunerative political post till the time I get elected again, which means after I'm disqualified, I can contest election again. Because if I'm disqualified from my seat in Legislative Assembly, that seat is vacant. When that seat is vacant, that means fresh election should be conducted to fill this seat. I can contest the election again, this time on the ticket of the Congress. And now once I'm elected on the Congress ticket, now Congress can appoint me a minister, can give me any post as well, any remunerative political post. But a defector is barred from taking any remunerative political post. Clear? But something else. When we look at this term, a member belonging to a political party, belonging to a house, if he voluntarily resigns from that party, disqualified. What will happen to that person? What is the status of that person who has been expelled by the political party? What will happen to this individual who has been expelled by the political party? Imagine a situation in Uttar Pradesh. Samajwadi Party, it was headed by Mulayam Singh Yadav. Now he's dead, unfortunately. His son, Akhilesh Yadav. But Mulayam Singh Yadav and his brother Shivpal Yadav, they were controlling the political party. There was one more gentleman, Amar Singh. Amar Singh was initially closer to Akhilesh Yadav. And Amar Singh was elected to Rajya Sabha on the Samajwadi Party ticket. Done? Mulayam Singh Yadav and Akhilesh Yadav, father and son, their relationship deteriorated. Now what happened in this case? Amar Singh took the side of Akhilesh Yadav. In fact, Amar Singh said that Mulayam Singh Yadav was not ready for the marriage of Dimple Yadav and Akhilesh Yadav. It was me who persuaded Netaji, Mulayam Singh Yadav, to arrange this marriage, to accept this marriage, to recognize this marriage. But be that as it may, Amar Singh was taking the side of Akhilesh Yadav. And Akhilesh Yadav and Mulayam Singh Yadav, their relationship deteriorated. Mulayam Singh Yadav, who was heading the party, expelled Amar Singh. When Amar Singh was expelled, Amar Singh was told, whip is still binding on you. That means Amar Singh was elected to Rajya Sabha on Samajwadi Party ticket. But because of anti-party activities, it was alleged that Amar Singh is indulging in anti-party activities, supporting Akhilesh Yadav and others. He was expelled from Samajwadi Party. When he was expelled from Samajwadi Party, he thought he's lucky. Said, now I can say whatever I have to say inside Rajya Sabha. No whip is binding on me. I can vote in favor of that bill, against that bill. I am now like a free bird. Samajwadi Party said, come here. Said, what? Whip is still binding on you. So what does that mean? If we tell you vote in favor of one bill and you vote against, you will be disqualified from Rajya Sabha. Right now, you're not disqualified. You're only expelled by the political party, but you're still a member of the Rajya Sabha. But your status is, although party has expelled you, but party whip is binding on you. Amar Singh said, this is cheating. He ran and approached the Supreme Court. My lord, hear my case. What? I am a member of the Rajya Sabha. Okay, we know that. We see you in various parties as well. But what's your point? You are mostly seen in Bollywood parties than in parliament. But that's a separate matter. Tell me, what's the issue? Sir, the issue is I am elected to Rajya Sabha on the ticket of the Samajwadi Party. I am not resigning from Samajwadi Party. If I resign from Samajwadi Party, I will be disqualified. But Samajwadi Party has expelled me. And now they're saying the whip is binding on you. If I vote contrary to this whip, I will be disqualified from Rajya Sabha. Please tell me, if they have expelled me, why should I abide by their whip? The Supreme Court said, Mr. Amar Singh, you will be deemed as an independent member of Rajya Sabha. Now you are an independent member of Rajya Sabha. But after your independence, if you join BJP or Congress or other political party or Mayawati's party, you will be disqualified under anti-defection law. Amar Singh said, sir, that I know. Why should I join another political party? I'm like a free bird inside Rajya Sabha. I can say whatever I have to say. Thank you so much. Few years later, things turned. Amar Singh patched up with Mulayam Singh Yadav. Mulayam Singh Yadav and Akhilesh Yadav, their relationship further deteriorates. Now this time, Amar Singh is again elected to Rajya Sabha on the ticket of the Samajwadi Party, but this time he's taking the side of Mulayam Singh Yadav and not Akhilesh Yadav. But now Akhilesh Yadav has controlled the party. When Akhilesh Yadav has controlled the party, Amar Singh, you are indulging in anti-party activities. You are expelled. When you are expelled, listen, whip is still binding on you. So this is cheating. Approach to Supreme Court. My lord, please hear my case. Oh, you're back again. Tell me, sir, I have been expelled. Again? Yes, sir. This time by whom? This time by the sun. And this time also, Amar Singh was declared as an independent member of the Rajya Sabha, which means the whip is not binding on you. But one problem with this law is that there is no clarity on when you are expelled. The law should be clear. The law is clear when it says, if you voluntarily resign, you will be disqualified. If you vote against the whip, disqualified. If an independent member joins a political party after the election, disqualified. If a nominated member joins a political party 6 months after the nomination, disqualified. But what will happen to this individual who has been expelled by that political party? The law is silent. That's why we need a reform. Reform so that this aspect is taken care of. Because every time we can't run to the judiciary. My lord, tell me, what is my status? Am I an independent or is this whip binding on me? That's why we need clarity, and that is reason number one why this law should be amended. Another issue. What do we mean by this term? If a member of a house belonging to a political party, if you voluntarily resign from your party, what do we mean by a voluntary resignation? Does that mean if I am a member of the BJP belonging to Lok Sabha, resignation would mean, voluntary resignation would mean, if I submit a written resignation letter to my party saying you are fascist, you are anti-Dalit, you are anti-women, whatever, these are my reasons, and that is why I'm resigning from your political party. Is this formal resignation? Is this voluntary resignation on the basis of which I can be disqualified under anti-defection law? But what if I'm still part of the Congress? Congress gave me the ticket to contest elections. I became the member of the Lok Sabha. Now I am the member of the Lok Sabha belonging to the Congress. I'm not resigning from the Congress, but I'm attending the meetings of the BJP. I have not resigned from the Congress, but I'm participating in the rallies of Mr. Modi. I am not resigning from the Congress, but I'm attacking the Gandhi family. I am not resigning from the Congress, but I am organizing rallies, protests, and programs and speaking ill of my political party. Can on this ground I will be disqualified? Can this be the definition of this term, voluntary resignation? That means even if you have not tendered formal resignation letter, but your conduct is such that we can safely assume that you have violated the party discipline, that you have resigned from your political party, then you can be disqualified as well. For example, Sharad Yadav, Ali Anwar, they belong to the JDU, and JDU decided to dump Lalu Prasad Yadav's party in the Congress and decided to join hands with the BJP and became the chief minister. Nitish Kumar became the chief minister. Sharad Yadav, Ali Anwar, who were the MPs of Rajya Sabha belonging to the JDU, they did not agree with this decision and started criticizing Nitish Kumar, started addressing rallies organized by the opposition, started participating in the programs of the opposition political party. Despite being called to come and be part of the meeting of the JDU, they did not come. So this conduct of Sharad Yadav and Ali Anwar outside the house, inside the house, you're still bound by the whip. Outside the house, if your conduct is such that we can safely assume that you have voluntarily resigned from your political party, you can be disqualified under anti-defection law. And that is how chairperson of Rajya Sabha then, Mr. M. Venkaiah Naidu, disqualified Sharad Yadav and Ali Anwar on the grounds of defection. Despite, because they did not voluntarily resign, they did not submit a formal resignation letter, but their conduct was such that we can safely assume that they have voluntarily given up their membership of the political party, they have voluntarily resigned. And this has been accepted by the judiciary in Ravi Naik case, in G. Vishwanathan case, in Shri Rajendra Singh Rana and others versus Swami Prasad Maurya case, 2007. In all these cases, the court has said this voluntary resignation does not mean that you have to submit a formal resignation letter. And then this formal resignation letter would mean that you have voluntarily resigned. If your conduct outside the house is such, even without submitting a formal resignation letter, if we can assume that you have voluntarily resigned from your party because you're not attending party meetings, you're attending the meetings of the opposition, you're criticizing your party, because party is very important under anti-defection law. If you violate that party, you're disqualified under anti-defection law. Is everything clear as of now? Senior members like Ghulam Nabi Azad. Ghulam Nabi Azad resigned from the Congress after his term in Rajya Sabha got over. Because if he would have resigned from Congress while he was member of the Rajya Sabha, he would have been disqualified. So first he enjoyed the post of the leader of the opposition in Rajya Sabha. He was not then re-elected to Rajya Sabha. And then he resigned from the Congress and started his own political party. Okay. But there are issues with anti-defection law. Apart from the fact that it does not clarify the position, what will happen to that legislator who has been expelled by the political party, there are other issues as well. Which are these other issues? Number one, there is no definite time period within which the speaker has to take the decision whether you should be disqualified or not. And even the court is helpless at the pre-decisional stage. What does that mean? Telangana. In 2014, and this law has been misused so many times that today we can say that this law is not working at all. It's a helpless law. How? Because politicians know how to manipulate this law. 2014, elections were held in Telangana. One individual, T. Srinivas Yadav, he belonged to the Telugu Desam Party, got elected to Legislative Assembly of Telangana on the ticket of the Telugu Desam Party. Now he has resigned from TDP, joined TRS, which is now BRS, and he was made a minister for cinematography and commercial taxes. Petition was filed before the speaker, disqualify him. This is a clear case of disqualification, clear case of defection. If you're elected to a house on the ticket of a political party, if you voluntarily resign from that party, you should be disqualified. Or even if he has not resigned, but you have made him a minister, disqualify him. The speaker is not acting at all. Whenever somebody approaches the speaker, speaker turns away. Don't tell me. I cannot disqualify him. Sir, please disqualify. He's violated anti-defection law. I'll take the decision. Right now, I'm having pain in the back. Sorry, but I'll take this decision very soon. And this soon never arrived. When it never arrived, people approached the High Court. My lord, please ask the speaker to take the decision and disqualify T. Srinivas Yadav. The court said we are helpless at pre-decisional stage. What does that mean? We have the power of judicial review. Once the speaker takes a decision, whether he says you are disqualified or whether he says you are not disqualified, then we come into the picture. Then we can decide whether the decision of the speaker is good or bad, ugly or beautiful, right or wrong. But first, he has to take the decision. We cannot interfere at the pre-decisional stage before the decision is taken by the speaker. And this is the problem of anti-defection law. There is no time limit. When there is no time limit, the speaker who belongs to the ruling party is playing the role of a partisan. Partisan in the sense, if the speaker of Telangana state would have been from the TDP, T. Srinivas Yadav would have been disqualified same day. But the speaker belongs to the ruling political party and T. Srinivas Yadav supports the ruling political party. No action is taken by the speaker. It's as if the speaker is sleeping. Kumkaran, sleeping. And whenever this defector is from the opposition political party, the speaker takes the decision in a flash. In a flash, Sharad Yadav, Ali Anwar were disqualified under anti-defection law. But T. Srinivas Yadav, for 5 years, he was made a minister. Despite defection, no action was taken. Then what is the solution? The solution is set the time limit. Set the time limit to the speaker. That please take this decision once the complaint is filed, once the petition is filed, take the decision in 1 month, 2 months, 3 months, 6 months, but for God's sake, take the decision in these 6 months. Or if we cannot prescribe time limit, then remove the speaker from this role, from this responsibility. If on the grounds of office of profit, change in the nature of citizenship, adjudged insolvent, mental unsoundness, if the decision is taken by the governor or the president on the report of the Election Commission of India, let's give this responsibility to the president or the governor that you disqualify somebody on anti-defection law grounds on the advice, on the report of the Election Commission of India. Remove the speaker because the speaker is partisan. Either prescribe time limit within which the speaker will have to take the decision, or give this responsibility to the president or the governor who will act on the report of the Election Commission of India. Clear? But something else. And this is where we say the democracy is at stake. Karnataka, Madhya Pradesh, Manipur. What happened in Karnataka? Elections were held to the Legislative Assembly of Karnataka. No political party got the majority. BJP in a house of 227 got close to 104 seats. Then there was Congress. Then there was Janata Dal Secular. No political party got the majority. When no political party got the majority, initially Mr. Yediyurappa was made the chief minister. We have discussed that. But since Mr. Yediyurappa could not prove his majority, he had to resign. And Indian National Congress and the JDS now formed the government. And they were governing and serving the people of Karnataka. Now, there is a new loophole which has been invented in anti-defection law. And what is that loophole? Resignations. What is the resignation? Imagine there are 200 MLAs. Imagine. And there are 3 political parties. I won't name them, but you will understand what I'm talking about. Political party A has 90 MLAs. Political party B has 80, for example. Political party C has 30. Who will form the government? Nobody, because nobody has the majority. Because what is the majority mark? 101. Now, in this case, what happens? Party B and party C, they decide to come together and form the government because now they have 110. 110 is more than majority mark of 101. And this political party A is sulking. But political party A has got something. Lure of money, threat, or power. This political party A is now approaching MLAs, either with money or with threat. You have indulged in corruption. Your case is with us. Enforcement Directorate will come and will arrest you. CBI will come and arrest you. National Investigation Agency will come and arrest you. But please save me. Resign. Resign and you are safe. Resignation is now a new loophole. What is this loophole? You are trying and you want to ensure that 30 MLAs, that means previously we were focusing on individual MPs and their resignation. That is where our focus was. If an individual MP resigns, disqualified. Now we are talking about group resignations, where 30 MLAs are resigning. When these 30 MLAs are resigning, what will happen to them? They will be disqualified. That means they are no longer member of the Legislative Assembly. And why will they resign? Because of money, because of threat, because of power. What is that power? These 30 MLAs are told, we will give you money in next election. Because these 30 MLAs, once you have resigned, these seats are vacant, we will give you the ticket to contest the elections. So you will alone contest these elections again, and then you will get elected. Once you are getting elected, we will make you ministers. And I promise you, this ministry for you, this ministry to you. So in lure of that power, in lure of that money, in lure because of those threats, you resign. Group resignations. But what is the purpose of this political party A to force these resignations? Because now the majority changes. Because the Chief Minister and Council of Ministers will remain in office as long as you have the majority in the Legislative Assembly. And what is that majority? Simple majority. Which means now because of these 30 resignations, the strength of the Legislative Assembly has now become 170. Any political party, if it has to form the government, needs more than half, which means it needs close to 85 MLAs, 86 MLAs. Now party A has 90 MLAs. Party B, for example, it has 60 MLAs now. And party C has 20 MLAs. So who is in a position to form the government? A. Resignations are now a new loophole. How do we tackle this loophole? some beautiful decision was taken in Karnataka by the Karnataka High Court. What Karnataka High Court said, a beautiful judgment. Karnataka High Court said, if these 30 MLAs have resigned, because in Karnataka, 17 MLAs belonging to the JDS and the Congress resigned, which was primarily meant so that the majority mark will come down and BJP, Mr. Yediyurappa, will be able to form the government on his own. Karnataka High Court said, if these 30 MLAs resign, what was their term? 5 years. If they spent 1 year as the MLA, what is the remaining term left? 4 years. These MLAs who resign and have been disqualified under anti-defection law, they are disqualified for the remainder of the period. That means for 4 years, they cannot contest elections. These 17 MLAs who defected from Congress and the JDS, and then they were disqualified. When they were disqualified, Karnataka High Court said you are disqualified for the remainder of the term. That means whatever term is left for that MLA, you will not get elected to that house. That means you can only get elected in the next election. These 17 MLAs approached the Supreme Court. And Supreme Court said, no, you're disqualified, but you are not disqualified from contesting the election again. Which means if after 1 year you have been disqualified, now fresh election will be conducted to fill these 17 seats. You can contest these seats again. And if you get elected, then you can be made a minister. You can even become the chief minister. Supreme Court was right as well as wrong. Right because after all, it is democracy. If these 17 MLAs defected, resigned from their political party, joined another political party, then let them go back to the public. Let public decide whether they agree with this defection or not. If the people vote for you again, that means we can say people are voting for you, not your political party. Because if they vote for political party, then if you contest elections again, then since your political party has changed, they will not vote for you. So it's democracy, it's people's rule. You're disqualified, but contest the election again. Contest the election again and let the people decide whether you can be elected or not. And out of these 17 MLAs, 16 MLAs were re-elected to the Karnataka Legislative Assembly. Which means if at all you think this is wrong, then blame the people of these constituencies. Because after all, that is democracy. And democracy means people's verdict. But you can't always use this democracy argument in these matters where people may be gullible. In a sense, if there is a rapist, can you also say tomorrow that there is somebody who has raped? He was an MLA. He raped and then he served 10 years in jail. During his period in jail, can he still be the member of the legislature? Can he contest election as well? I want to represent this constituency from my jail. Who is Supreme Court to decide? That's for the people to decide. But can people be asked to elect a criminal? No. In the same fashion, you have to make law, and through this law, govern the mindset of the people. And the best verdict should have been Karnataka High Court's verdict. You're disqualified, and you're disqualified for the remainder of the term. Which means these MLAs will not, for the money, for lure of power, because of some threats, will resign. Which means they would know that they cannot become the Legislative Assembly MLAs again for the next 4 years. They will not resign. They will stick to their party. When they stick to their party, that means stability of the government will be strengthened. Similarly, this happened in Madhya Pradesh. It happened in Madhya Pradesh where 22 MLAs who owed allegiance to Jyotiraditya Scindia, they resigned from Congress, were disqualified under anti-defection law, joined the BJP, contested the election again, and won on the BJP ticket. Not all of them won. 8 or 9 people lost as well. But the remaining, they won the election. And that is how a new government was formed in Madhya Pradesh, which means resignations, mass resignations are now a new loophole in anti-defection law. But something bizarre happened in Manipur. In Manipur, elections were held. Elections were held and a Congress MLA was elected, T. Shyamkumar. He resigned from the Congress, joined the BJP, was made a minister, forest minister. Matter went to the speaker. Speaker take the decision, disqualify T. Shyamkumar. Speaker is not taking the decision. Please take the decision. Not taking decision. Matter went to the Supreme Court. Supreme Court was told, sir, now you have to do something because this law is getting misused like this. Yes, we know Telangana court has said that we are helpless at a pre-decisional stage. First, the decision should be taken by the speaker. Then you can come into the picture. Then you can review. But that way, if the speaker does not take any action, which means you cannot come into the picture, which means you cannot review, which means you're not exercising your judicial review properly. The Supreme Court said, no, but we have to do something, but we will still give opportunity to the speaker. Speaker, take the decision in 3 weeks. 3 weeks were over. Case went back to the court. Speaker was asked by the Supreme Court, have you taken the decision? Speaker said, give me 1 more week, please. This is like a delaying tactic. 3 weeks, 1 more week, 1 more month, 2 more months. By the time the term of Manipur Assembly is over, the Supreme Court said, enough is enough. Supreme Court invoked Article 142 of the Constitution. And Article 142 says Supreme Court can give any order so as to give complete justice. Supreme Court said, one judge of the Supreme Court was Justice Rohinton Fali Nariman. Justice Rohinton Fali Nariman said, T. Shyamkumar, you are removed as a minister. Who has the power to appoint a minister? Governor. Who has the power to remove a minister? Governor on the advice of the Chief Minister. Now this time Supreme Court is removing a minister because Supreme Court can do anything under Article 142 to give complete justice. Supreme Court said, T. Shyamkumar, you are removed. When T. Shyamkumar, you are removed, don't you dare enter the Legislative Assembly. And when you can't enter the Legislative Assembly, Speaker, take the decision now. Take the decision now. We have already removed him. Now take the decision. Otherwise, we will take action against you as well. Speaker got scared and disqualified T. Shyamkumar. But a beautiful observation was made by Supreme Court. Supreme Court said a time has come when Parliament should have a rethink on whether disqualification petitions ought to be entrusted to a speaker as a quasi-judicial authority when such a speaker continues to belong to a particular political party. Because the speaker is now acting like a quasi-judicial authority. It has to investigate whether T. Shyamkumar has incurred defection or not, whether he should be disqualified under anti-defection law or not. So the speaker is acting like a judge. So it's a quasi-judicial body. Although you're not a complete judge, but you're acting in a judicial capacity. Rohinton Fali Nariman, the judge of the court, said it is time for Parliament to have a rethink. Can we give this responsibility to decide disqualification petitions? Can we give this responsibility to a speaker who always belongs to the ruling party, who always belongs to a political party? We need a rethink. And what is that rethink? Perhaps we need to follow what is followed in United Kingdom. Once a speaker, always a speaker. What is this once a speaker, always a speaker? I am the Speaker of Lok Sabha, Mr. Om Birla. Government is telling me, suspend these 10 MPs from the opposition. I said, really? Suspend them. This won't look nice. Suspend them, otherwise we will not give you the ticket to contest the next election. Okay, suspended. Don't give them opportunity to speak in the Lok Sabha. Shoot them down. No, expelled. This bill, certify it as a money bill. But this is not a money bill. I said certify this as a money bill, otherwise we will not give you the ticket to contest the next election. So this is a threat, contesting the next election. Because if I cannot contest the next election, that means I will not be the representative of the people. I will not hold this power. In United Kingdom, if you are elected as a speaker, you remain a speaker forever. If I am Mr. Om Birla, appointed as a speaker, elected as a speaker, now I don't have the fear of anybody. I am once appointed as speaker, I will always remain a speaker unless and until I resign or I've been removed by the parliament. For that, they require effective majority. But if I'm doing good, opposition will not support the removal. If I'm doing good, then the government and the opposition, if I'm doing bad, then government and the opposition will come together to remove me. But if I'm doing good, I'm impartial, I cannot be removed. I will remain speaker forever and ever and ever unless and until I resign. And what will happen in the next election? From my constituency, no political party sets up a candidate, which means from my constituency, I will be elected unopposed and I will come back to Lok Sabha and I will keep on taking my chair of the speaker. So if somebody is threatening me, don't give them opportunity to speak. Tell them why. I have to give them opportunity. We will not give you the ticket in the next election. Sorry, we can't do that. And that's how we can maintain impartiality in the office of the speaker. And that is the question which was asked in one of your mains examination. Once a speaker, always a speaker. Should this practice be adopted to impart objectivity to the office of the Speaker of the Lok Sabha? Besides, what could be its implications for the robust functioning of the parliamentary business in India? And that completes our discussion on Anti-Defection Law 10th schedule. Any questions? Let me know. Yes, I will give you a break. Be patient. First, if you have any questions, let me know. Does it not give an unbridled power to presiding officer as decisions are kept pending indefinitely? Absolutely yes. That is why we say it's a toothless law. Also, the law interferes with the members' freedom of speech and expression. Does it stand valid even under defection? Please. That is why there is a demand that whip should be binding, and we have discussed this previously, only in cases where stability of the government is under threat. For example, if citizenship amendment bill is passed or defeated, nothing happens to the government, government survives. If farm bills are passed or defeated, nothing happens to the government, government survives. So on these bills, on these issues, I as a member of the ruling party, I should have the freedom to say whatever I have to say. I should have the freedom to vote in favor or against. That should be my individual freedom. But then there are some areas where the stability of the government is under threat. Money bill, for example. Money bill is defeated, the government gone. So for money bill, whip should be binding on me. Motion of thanks on president's address. If it is defeated, government is censured. Adjournment motion. Similarly, no confidence motion. That is why, in fact, there was a private member's bill introduced by Manish Tiwari. Manish Tiwari is a member of the Lok Sabha, but does not belong, is not a minister, so he becomes a private member. He had introduced a private member's bill. In fact, when Congress was ruling, but then he was not the minister. Later on, he was made a minister. When he was a private member, he had introduced a bill that whip should be binding only in these instances. And on all other instances, legislators should have the freedom of speech and expression. But this bill has not been passed. But this can be another reform. Is whip binding in president's election? President's election is done through secret ballot. So there is no whip. You have to vote based on your conscience. Sir, if Speaker himself is under disqualification, how can he decide other MPs' disqualification? And that is what the Supreme Court has said in Nabam Rabia case. If the Speaker under him removal motion is pending. The speaker cannot decide on defections. And this is something curious as well. What is so curious? Nabam Rabia judgment 2016, Supreme Court said if there is a speaker against whom there is a motion pending in the Legislative Assembly for his removal, because speaker can be elected by simple majority and can be removed by effective majority. What if a motion is pending in the Legislative Assembly calling for the removal of the speaker? And what speaker does? Speaker looks at who are these people who have introduced this motion. Speaker disqualifies them under anti-defection law. That can also happen. The Supreme Court in Nabam Rabia case said no. When a motion is pending in the Legislative Assembly calling for the removal of the speaker, then this speaker cannot act under anti-defection law, cannot disqualify somebody under anti-defection law. This was to prevent a situation where the speaker will disqualify those under anti-defection law who seem to have introduced this motion for his removal. But now something else is happening. There were close to 15 MLAs or 14 MLAs belonging to Shiv Sena who were to be disqualified under anti-defection law. Because the Shiv Sena said, Uddhav Thackeray said that these MLAs, they have defected, please disqualify them. As soon as I am about to take that decision to disqualify them, they take help of Nabam Rabia judgment. And what do? They introduce a motion to remove me. Now I have to take a decision to disqualify them. Now they counterattack and they introduce a motion to remove me as a speaker, which means now my hands are tied because of Nabam Rabia judgment. I cannot act on this disqualification petition. That's exactly what happened in Maharashtra. And that is why now the court has to hear this matter. What is now the final position of the Nabam Rabia judgment? That's for the court to decide. Because if I have to disqualify you, you can save yourself from disqualification by introducing a motion for my removal. Then I cannot take any action. Can speaker vote against motion which is for his removal? Speaker normally has a casting vote. What is this casting vote? For example, there's a bill in Lok Sabha. This bill should be passed by majority. That means more than half, more than those who have voted against. Now this bill is pending in Lok Sabha. 200 MPs are in favor of this bill. 200 MPs are against this bill. That means there's a deadlock. 200 in favor, 200 against. I am the speaker. I have the casting vote. That means my vote will be given whether in favor of this bill, which will mean that the bill is passed, whether against this bill, which means the bill is defeated. So the speaker does not vote in the first instance. Speaker votes only in case there is a tie. First instance means I am the speaker. I give this bill to the Lok Sabha. All those who agree with this bill may say A. All those who are against this bill may say no. I think the A's have it, the bill is passed. And now opposition says, let's have division. Let's see how many are in favor, how many against. I'm not voting in that instance. I'm asking the MPs to vote. 200 said yes, 200 said no. In this case, what I will do, I will have a casting vote. I will give vote either in favor of this bill or against. If it is in favor, the bill is passed. If it is against, the bill is dead. But if there is a motion pending for my removal, motion has been introduced that speaker, you are to be removed. MLAs or MPs will have to give me 14-day notice. And let's say now there is voting, whether speaker should be removed or not. And voting should take place by effective majority. I will not sit on the speaker's chair. I will sit in the Lok Sabha. And there I am like an individual MP. I will vote in the first instance. And naturally, I will vote to save myself. I will vote in my favor. That means when a motion is pending for the removal of the speaker votes in the first instance, not at the time of the tie. Clear? Can any independent candidate contest elections in the speaker constituency? Madam, that is a reform suggested in India that we will follow like what is followed in Britain. Once a speaker, always the speaker. That means in speaker's constituency, no political party will set up a candidate. No political party. This has not happened in India. So Mr. Om Birla, if he has to contest elections again, he will go back to his constituency in Rajasthan and contest the election again. And anybody can contest against him. Anybody, whether from Congress, whether from Aam Aadmi Party, whether from my party or independent. Can governor president disqualify candidate on grounds of defection when speaker is not responding? No. How can a nominated member join a political party? Within 6 months of his nomination, he can join a political party. Sir, now in Maharashtra, Shiv Sena MLA make government with BJP. Here, no anti-defection law against them. No anti-defection law ideally would happen in this case. Because it's like Shiv Sena MLAs, they have not joined the BJP. They have joined government. And in government, you can have different political parties come together. So joining a government is not a ground for disqualification. Joining a political party is a ground for disqualification. As chairperson of Rajya Sabha, Vice President has the right to disqualify. Yes, Vice President as the chairperson of Rajya Sabha decides on these disqualification petitions. So can we say that merger these days is misinterpreted as split? Yes. Can removed speaker become speaker again? When you say can, yes. But if, imagine a situation, I am removed as a speaker, which means I don't have the majority. When I contest the election again for the speaker, even then I will not have the majority. If I had the majority, I would not have been removed. But yes, technically, if a speaker has been removed, he can contest again. Are there vice governors? No, there aren't vice governors. There is no such thing as deputy governor. Okay, let's meet. It's 8:55. 9:10 a.m. and we will we'll start discussion on center-state relations. See you on the other side of the break. Shall we resume? So 2/3 MLAs split and form another political party, then is it allowed as per anti-defection law? Split is not allowed. Merger is allowed. Two political parties can merge, but this merger should be supported by 2/3 of the legislative wing of that party. Then how Shiv Sena members who formed another political party are not disqualified? These MLAs did not form a new political party. These 40 MLAs who rebelled against Uddhav Thackeray, they said, we are the real Shiv Sena. So they haven't formed a new political party. Can Speaker take a decision of voluntary resignation without formal resignation suo motu, that is without formal complaint by the political party? No, with the complaint by the political party. Can chairperson of a house take a decision on the removal of legislators and under anti-defection law when a motion of removal of chairperson is pending against himself? No, you cannot take that decision. It applies to the presiding officer, whether speaker or deputy speaker, because in case of Maharashtra, it was against the deputy speaker because there was no speaker. There was a motion of removal against the deputy speaker pending. And based on Nabam Rebia judgment, this deputy speaker could not disqualify those legislators. Okay. Now let's start with center-state relations. Center-state relations can be divided into three big categories: center-state relations, legislative relations, administrative relations, and financial relations between the center and the state. Financial relations between center and the state has changed because of the GST era with the introduction of the goods and the services tax. In financial relations, we have to also talk about Finance Commission. Every 5 years, President, under Article 280 of the Constitution, constitutes a Finance Commission headed by the chairperson and 4 other members. What is the principal objective of this Finance Commission? That there is money in Consolidated Fund of India. This money is through taxes, through investments, through FDI, whatever it is. This is what we call divisible pool of tax. That means whatever money is there, it is to be distributed and shared with the states. Clear? Because if the taxes are imposed by the center, whether it is income tax, whether it is corporate tax, but who pays income tax? You and me. I may be from Karnataka, you may be from Maharashtra, basically a state. Corporate tax, for example, those corporates which are established in Bengaluru, those corporates which are established in Chennai or Hyderabad, basically states. That means these taxes which have been imposed, whether income tax or corporate tax, which is imposed by the center, which is collected by the center, but it is to be shared with the states because after all, we have received these revenue from the states. What is the formula that we have to use for that? On what grounds should we distribute this tax revenue with the states? That is decided by Finance Commission, which is constituted every 5 years under Article 280 of the Constitution. Clear? But when it comes to GST, when it comes to Finance Commission, when it comes to financial relations between center and the state, there is an overlap. Overlap between economics and polity. Because same things would be discussed by me in this class. Same things would be discussed by Sham sir in the economics class as well. So why have an overlap? That is why financial relations between center and the states, we shall discuss in economics. Because there larger tax issues, tax measures, debates will be conducted. That would be much relevant if we discuss these matters in the economics classes. In polity, we will focus on politics, legislative and administrative relations between center and the states. The financial relations will be dealt by Sham sir in the economics classes. Clear? Let's look at legislative relations, where we have to discuss Articles 245 to Articles 255 of the Constitution. But you don't have to remember and memorize these articles, just understand the concept. And what is the concept? What is the territorial extent of central and state legislation? The law passed by the Parliament will be applicable throughout the territory of India. The law passed by the state legislature will be applicable within the territory of that state. For example, Madhya Pradesh, for example, Uttar Pradesh, they have passed some laws known as the Love Jihad laws. Will these laws passed by Uttar Pradesh apply to Karnataka as well? No. Will the law passed by Madhya Pradesh apply to Chhattisgarh as well? No. Why? Because what is the territorial extent? The laws passed by the state legislature will be valid, will be enforced within the territory of that state. Normal. But the laws passed by the Parliament will be applicable throughout the country, which means when Citizenship Amendment Act is passed, this law will be applicable how Parliament decides. And Parliament decided that this law will be applicable throughout the country except those states, except those regions, except those areas which are known as scheduled tribal areas under 6th schedule of the Constitution. So Parliament decides whether the law will be applicable throughout the country or some areas will be exempted. But normally this law passed by the Parliament applies throughout the territory of India. And Parliament alone can make extraterritorial legislation. What is this extraterritorial legislation? That means the laws passed by the Parliament will apply to Indian citizens abroad as well, will apply to their property abroad as well. How? Let me give you one example. Something known as black money. Although this is a racist term, everything bad, we call it black, everything good, we call it white. It's a racist term. Black money basically means unaccounted money. What is unaccounted money? For example, this is my land and I want to sell this land to you. And I tell you, give me 1 crore rupees and take this land. But I'm also telling you, you give me 40 lakh rupees in my bank account, 60 lakh rupees in the form of cash. When it is 60 lakh rupees in the form of cash, that means on this money, I don't have to pay tax to the government because government does not know this money. This is stored and stashed in my home. But on this 40 lakh, which is there in my bank account, I have to pay tax to the government. This 60 lakh is unaccounted money, and this unaccounted money is known as black money. Now this money, where can we have this money? This money, there are some individuals, wealthy individuals, who basically withdraw this money and send this money abroad. Abroad, for example, in Swiss banks, in banks where there is a lot of confidentiality, where nobody gets to know who is the owner, who is the controller of these bank accounts. Now, there is a solution to black money. And what is the solution? One solution prescribed by Dr. Subramaniam Swamy. Dr. Swamy says, Indian government should nationalize all the bank accounts held by Indians outside India. When you nationalize all these bank accounts held by Indians outside India, that means all these bank accounts of the Indians outside India will now be under the government of India. Basically, Dr. Subramaniam Swamy says that money is black money. But who can pass such a law? Can state legislature pass such a law? Or can Parliament alone pass this law? Only Parliament. Why? Because this law has extraterritorial jurisdiction. That means this law is applicable beyond the territory of India. But this law cannot be applicable in Pakistan. Indian Parliament cannot make a law on Pakistan or China or Sri Lanka. It is only Indians residing in Pakistan and China. This law can be applicable to them. Long story short, although you know this, but let's reiterate. The laws passed by the Parliament shall be applicable throughout the territory of India because Parliament has the jurisdiction over entire country. State legislature passing a law, this law will be valid, will be implemented, will be applied with respect to the territory of that state. and Parliament alone has the power to legislate, to make extraterritorial legislation, which means Parliament can make a law which is applicable to Indian citizens and their property anywhere in the world. Clear? This is where we come across another important concept, and that concept is known as doctrine of pith and substance. What is doctrine of pith and substance? Schedule 7 of the Constitution, Article 246, which talks about Schedule 7, it talks about distribution of legislative subjects. What is this distribution of legislative subjects? On what items can Parliament make a law? All those subjects are mentioned in Union List. On what items can the state legislature make a law? That too in normal circumstances. Those subjects are mentioned in the state list. But then there are some subjects on which both Parliament as well as state legislature has the power to make a law. And those are mentioned in concurrent list. For example, in Union List, we have defense, external affairs, communication, railways, ports, post and telegraph, citizenship, extradition. Extradition means if there is an individual, Abu Salim, for example, or Dawood Ibrahim. Dawood Ibrahim is there in Pakistan. Can we extradite Dawood Ibrahim from Pakistan to India? For that, there has to be a law, there has to be a treaty between India and Pakistan, that if there are some terrorists on Pakistani soil who are wanted in India, let's have an agreement, bring them to India. If there are terrorists in India belonging to Pakistan, let's have an agreement and bring these terrorists to Pakistan. For example, Abu Salim, a gangster, he was there in Portugal. Lisbon is the capital of Portugal. And Portugal and India had an extradition treaty. That means if Abu Salim is wanted for crimes in India, Abu Salim can be extradited from Portugal to India. For that, who has the power to make a law on extradition? Parliament alone. But then the state legislature also has a power to make a law on its own items. For example, law and order, land, police, agriculture, gambling. On all these, who has the power to make a law? State legislature. But in normal circumstances. What are these abnormal circumstances? For example, yesterday we discussed emergency provisions. When national emergency is imposed in a particular state, who can make a law for that state? Parliament. That means legislative assembly of that state is continuing. But Parliament enjoys the concurrent power along with that state legislature to make a law on land, law and order, agriculture, gambling, any law, any subject placed in the state list. Or when there is president's rule, when there is no legislative assembly, who makes law for that state, for that union, for that state list subjects? Parliament. That means distribution of legislative subjects is such that Constitution has divided and distributed legislative subjects. Some power, some subjects given to the center, some given to the states. But on some, both Parliament as well as state legislature has the power to make a law. For example, education. For example, criminal procedure. For example, marriage. For example, divorce. On all these matters, both Parliament as well as state legislature has the power to make law. But imagine a situation on criminal procedure, on IPC, for example, Indian Penal Code. Parliament can make a law, state legislature can also make a law. What if parliamentary law and state law are not compatible with each other? Compatible in the sense, Parliament says for this crime, the punishment is 10 years. And state legislature says for this crime, the punishment is 8 years. What will prevail? In case of a conflict, it is the parliamentary law which will prevail. Clear? But if state legislature introduced a bill saying for this particular crime, the punishment is 8 years only. And this bill is then reserved for the consideration of the president. And if president signs this bill, that means the center has accepted that it is the state law which will prevail, not the parliamentary law. Otherwise, if there's a conflict between the state law and the parliamentary law will prevail. But if the state law is reserved for the consideration of the president, and president on the advice of the prime minister says, okay, we have no problem with this law passed by Punjab, then this law in Punjab will be applicable, which is the state law, even if it is not compatible with the law passed by the parliament. That is what we call distribution of legislative subjects. But in this distribution of legislative subjects, we come across an issue. What is the issue? Rajasthan, for example, passed a law and said loudspeakers should be banned after 10 p.m. and before 6 a.m. In this period, loudspeakers should be banned. Why? It should be banned to support public health. Health is a state subject. That means in distribution of powers on health, who can make a law? State legislature. Loudspeakers deal with communication. And in the distribution of powers, communication is under the union list. That means who has the power to make a law? Parliament. On this subject, who has the power to make a law? State legislature. Loudspeakers should be banned. Why? Because there are students studying. You're studying for the civil services examination. And you study mostly during the night, because that's how most of the students study during the night, because that's how they think they can concentrate without any noise coming from abroad, coming from outside. Or there are patients suffering from heart ailments, suffering from other ailments. Or there are lactating mothers, pregnant ladies. They get affected by these loudspeakers and the noise coming from the loudspeakers. So at least during the night, they should not be disturbed. Ban the loudspeakers after 10 p.m. and before 6 a.m. Why? Because we want to protect public health. Matter went to the court. That Rajasthan Legislative Assembly cannot pass this law. Why? Because Rajasthan Legislative Assembly is passing a law on communication on loudspeakers, which is under union list. How can you restrict the use of loudspeakers when loudspeakers are part of communication? Communication is under union list. Only Parliament has the power to make such a law. Rajasthan said, no, we are passing a law which is within our competence, because we are passing a law which is under public health, and health belongs to the states. In this conflict, where both are right and both can be wrong as well, the Supreme Court has found a solution. And the solution is doctrine of pith and substance. Supreme Court in these matters, when a law is passed by one entity, can be Parliament, can be state legislature. But this law seems to encroach into the legislative competence of other body. For example, parliamentary law is seen to be encroaching into the state domain, or a state law is seen to be encroaching into the parliamentary domain. In this conflict, what will prevail? Supreme Court said, we will look at this from the prism of pith and substance. The Supreme Court said this Rajasthan law is constitutional. Why? Because the basic purpose, the basic substance, the heart of this matter is, Rajasthan is not trying to regulate communication. Rajasthan is trying to protect public health. So it is for public health that Rajasthan wants to ban loudspeakers during a particular period. This law is valid because Rajasthan deals with health. That is what we call doctrine of pith and substance. The courts, if there is an allegation that one body, Parliament, is encroaching into the state subject, or state legislature is encroaching into the parliamentary subject, in this case, whether this law is constitutional or not, Supreme Court will look at what is the ultimate objective of this law. If the ultimate objective is within your competence, this law is constitutional. Because Rajasthan, you want to regulate public health, protect public health, improve public health, it is within your competence because health is under the state list. This law is constitutional, even if there is incidental encroachment into communication which comes under union list. That's doctrine of pith and substance. But something else. If legislature, the state legislature is empowered to make a law on agriculture, then how did Parliament enact the 3 farm laws, which were later repealed as well? But how can Parliament make a law on agriculture because agriculture is within the competence of the state legislature? For that, we need to understand very briefly what these 3 laws are talking about, what these 3 basically farm laws talked about when they were passed in 2020. The first was Farmers Produce, Trade and Commerce Promotion and Facilitation Act of 2020. What does that mean? For example, I'm a farmer. I sow a crop. Let's say the crop is paddy. I want to sell this crop. Where do I sell this? I go to a mandi. What is that mandi called? APMC. Agricultural Produce Market Committees. It's a mandi basically. So I take this paddy, go to the mandi. Which mandi? Nearest mandi that I have. For example, if I'm from Punjab, I will go to Gurdaspur mandi, which is very close to me. I can sell this paddy in the Gurdaspur mandi. And their auction will take place. All those who want to buy this paddy, they will, through an auction, will decide what is the price that will be given to me. Clear? But can I sell this paddy in a different APMC mandi? Let's say there is a different APMC mandi in Ludhiana. I was basically allowed to sell it in Gurdaspur. I sold it in Gurdaspur. But there is another APMC mandi in Ludhiana. Can I sell it there as well? I can. But for that, I have to pay tax to the government, tax to the state government. Can I sell this produce not in an APMC mandi in Punjab, but in Haryana or in Rajasthan? I can, but for that, I have to pay tax to the government, tax to Haryana, tax to Rajasthan. This Farmers Produce Trade and Commerce Promotion and Facilitation Act 2020 said, this paddy, which is of a farmer, he can sell this in his nearest APMC mandi or in any mandi within that state or in any mandi throughout the country without any need to pay the tax. Why? Because this is for the farmer's benefit. Why farmers benefit? Because if I don't get better produce, if I don't get better money, if I don't get better value for my produce in Ludhiana, I will go to Gurdaspur. If not there, I will go to Haryana. If not Haryana, then I will go to Rajasthan. Wherever I will get the best value for my produce, I will sell it there. And for that, the law was passed by the Parliament. But how can Parliament make a law on agriculture? Because agriculture is within the domain of the state. Not just agriculture, even agriculture marketing is within the domain of the state. Not just agriculture marketing, markets and fairs are also under the domain of the state. Agricultural Produce Market Committee, this mandi, it's a market for my produce. Markets can be regulated by the states, not by the Parliament. So how can Parliament pass such a law? That's issue number 1. Issue number 2, Farmers Empowerment and Protection Agreement on Price Assurance and Farm Services Act 2020. What this law basically did, it gave a national framework for contract farming. What is contract farming? I am a farmer. I have this land. Now comes a multinational company, for example, Frito-Lay's, PepsiCo. They come, they give me seed. This is the potato seed. Sow this, and all the potatoes that will be grown, I will buy it. And I will buy it at a predetermined price. So PepsiCo is giving me seeds. I have the land, sow these seeds. And once the crop is produced, Let's agree today. What will the price be when I will buy it from you? We determine it before. That's what we call contract farming. And for that, the law was passed by the parliament in 2020. But the question is, agriculture is within the domain of the state. How can parliament pass such a law? That's question number 2. The third one was on Essential Commodities Amendment Act. What is an essential commodity? For example, inflation or food inflation is high. What do we mean by inflation? Inflation in simple terms means rise in the value, rise in the prices of essential commodities, together with fall in the value of the rupee. How? I have 100 rupees. I go to a grocery shop, I buy 1 kg of onion. For example, tomorrow I go to the same shop and he's saying now this 1 kg of onion costs 200 rupees per kg. What does that mean? That means the price of onions have increased. This is inflation. But not just the price has increased, even the value of your rupee has decreased. Because previously, this 100 rupee had a value. It could give me 1 kg of onion. But now the same 100 rupee, its value has decreased. Now it will give me only half a kg of onion. This is inflation. And inflation is because of a lot of factors, which we will discuss in economics, but very briefly here. Inflation can be because of the demand, or inflation can be because of the supply. In the sense, if the demand for onions is high, demand is high, which means you will be willing to pay more money to buy this. When the demand is high, I will pay you more. For example, mandi. What happens in a mandi? Auction takes place. There is a lot of demand coming from various sellers, various buyers that give us these quintals of onion. When I see that there is a lot of demand, I increase my price. I say instead of 100 rupees per kg, give me 200 rupees per kg. They will buy it. Why? Because they demand it. Because they know that people are also demanding it right now. Maybe it's a marriage season. Maybe something else. So demand for a particular produce, if it increases, inflation also increases. If the demand goes less, price also comes down. If the demand is less, that means there are hardly any takers for onions. I tell them 100 rupees per kg. They said, no, we don't need it. There is no demand. Please take 50 rupees, give 50 rupees and take this. Is it okay? So if the demand is less, price will come down, inflation is down. Or it can be because of the supply. Supply in the sense, monsoon failed. When monsoon failed, which means the crops and their production also reduced. That means now the supply of food items in the mandi has reduced. That is what we call supply shock. So supply has been affected. When there is less supply, the demand is still the same. Ultimately, for this smaller supply, less supply of produce, there will be more and more people who will demand this. Ultimately, the price will increase. But it is also happening, inflation is also happening because of the black marketers, whom we call hoarders. Who are these hoarders? For example, I know that onion prices will increase after some time. I buy 100 quintals of onions and store it. I don't release it in the market. I hoard it. I stash it. This is similarly, it is done by others. They also take 100 quintals of onions and stash it, hoard it, don't reveal it, don't open up this in the market. Which means now what these people are doing, hoarders are doing, black marketers are doing, they are creating an artificial scarcity of onions. There are onions lying in the godown, but these onions are not there in the open market to be sold, which means you are creating artificial scarcity, which means you are creating less supply. When the supply is less, prices will go up. So I bought this 100 quintal for 100 rupees a kg. When I see the price goes up, it reaches 250 rupees per kg. I will now supply this onion and sell it for 250 rupees a kg, 275 rupees a kg. To prevent this from happening, the government, the parliament has passed a law known as Essential Commodities Act. If the government says that onions are an essential commodity, once onions are the essential commodity, whoever is hoarding all these onions, these onion deposits or these onion stores will be confiscated by the government and will be thrown in the open market, which means you were hoarding onions. Now these onions, because they are declared essential commodity, beyond a certain limit, you cannot have this stock of onions, which means above this limit, whatever onions you have to release it in the open market, which means we are taking care of the supply side, which means we are now stabilizing the prices. 2020, the parliament decided that some items such as onions, such as tomatoes, such as potatoes, such as oilseeds, they are removed from essential commodities. When they are removed from essential commodities, that means you can hoard as much onion as possible. Why? Because the government thought that this is good for those who invest in cold storage facilities. What is cold storage facility? Which we will discuss in economics, but very briefly here. The point is that there are some perishable goods whose lifespan is short. If these perishable goods are thrown in the open market, their shelf life is small. That means after that they will rot. Then there is no value. So what will a farmer get? Nothing. Because whatever is your produce that is now rotten, the shelf life was less, you get nothing. This is where multinational companies or industrialists, what they do, they invest in cold storage facilities. They build facilities, basically fridge, freezers, cold storage facility, because if a produce is stored in this cold facility, then because of respiration, you can store this food for a long period of time. It will not rot. It will not turn stale. The government thought if we remove onions, potatoes, tomatoes, oil seeds from Essential Commodities Act, it basically will give an opportunity to the corporates that you can invest in cold storage. Because if you invest in cold storage, which means you are storing a lot of onions and potatoes and tomatoes in the cold storage, for example, which means if this is now an essential commodity, that means government can at any point in time come to your cold storage facility, and if you have stock which is greater than above the level, all these stocks can be confiscated and thrown in the open market. Then why would a corporate invest in constructing cold storage facility? That is why some items were removed from the Essential Commodities Act. And farmers basically alleged that all these laws will favor the rich, will favor the upper sections of the society, will favor the corporates. Why? Because, for example, today, if I'm selling my produce in a nearest APMC mandi, I have a traditional relationship with this mandi. Traditional relationship in the sense, I don't have to even go to the mandi. I know a person there. He's taking care of my produce. His father was taking care and having business with my father. So we have personal connect with each other. If this mandi survives, I will survive as a farmer. So what I do, I give him my produce because I know he will get the best price for my produce, best value for my produce. Farmers think, or they believe, whether misconception or real threat, they believe that if I am allowed to sell this produce, not only in the nearest APMC mandi, with whom I have traditional contact, traditional relationship, but with other APMC mandi, or with other APMC mandi outside the state, or I can sell it directly to a corporate house as well, then what will happen? Initially, Adani and Ambani, they will give me good price for this, good value for this crop. Good value. APMC mandi would give me 100 rupees per quintal. Adani will give me 1000 rupees per quintal. So I will sell it to Mr. Adani. Done? But over a period of time, what will happen? These APMC mandis, they will be gone. Now they will show their true colors. And Adani will say, I will give you only 10 rupees a kg. I had the option of going back to the APMC mandi, but it has been destroyed now. There is no business there. APMC mandi is gone. Just like Reliance Jio. Initially, all calls free, data free, whatever you do, free. Now IPL streaming free. But once you have lured customers onto your platform, then you will start charging. For every phone call, now there will be a charge. For data beyond a limit, there will be a charge. And that is how Reliance Jio is now a profitable venture. That's what farmers fear. And farmers fear that when contract farming is legalized by the center or contract farming rules are made by the center, what will happen? Number one, I'm a farmer. I may not be literate. So when I'm entering into a contract with a multinational company, PepsiCo, I would not know what is mentioned in this contract. Maybe I will be bound by this contract, which I'm not completely aware of. And this has happened. In Gujarat, for example, Lay's or PepsiCo, they gave seeds to farmers to buy these to sow these seeds and get potatoes. And these potatoes, two things have happened. One, the farmer is selling some of these potatoes to some others as well. PepsiCo is saying, how can you do that? You're violating the contract. I was not knowing that this is part of the contract, number one. Or I was knowing it, but I'm still selling it to others. That's number one. Number two, when this contract was started, it was argued that the shape of this potato should be like this. The size of the potato should be this. Only then I will buy these potatoes. If the shape is disfigured, which I cannot use for snacks, then I will not buy these potatoes. It's mentioned in the contract. But I, as a farmer, I don't know all these nitty-gritties. So I will be bound in a contract. And if there is a dispute, these multinational companies, they can pay crores of rupees to their lawyers. But where will we get the lawyer? That is why farmers say we don't need this contract farming. And when you say Essential Commodities Amendment Act, some of the items have been removed from essential commodities list. For example, onions, which basically means you're allowing the corporates to hoard a large value, large stock of food grains, creating artificial scarcity in the market, thereby leads to inflation. So farmer has sold this produce for 10 rupees a kg. You hoard it and then sell it. And when you sell it at 200 rupees a kg. So what will a farmer get? Nothing. Whether these are misplaced objections or definite objections, that is for the farmers to decide. So we don't have to go into the politics of it. But what we have to go into is the polity of it. And the polity says clearly that agriculture is within the domain of the states. So how can Parliament pass a law? Agriculture is a state subject. If you look at list 2, which is state list, entry 14 will tell you agriculture. This is within the domain of the state. Entry 26 in the state list talks about trade and commerce within the state. That means whether it is APMC Mandi in Ludhiana or Gurdaspur, state legislature has the power to regulate it. Why is Parliament doing this? Production, supply and distribution of goods. Production of food grains, supply of food grains, distribution of good food grains, that is within the domain of the state legislature. Why is Parliament enacting a law? Markets and fairs. That means APMC is a market. This market, who can regulate it? State. Which means agricultural marketing also is considered to be within the domain of the state. So if agriculture is a state subject, markets and fairs is a state subject, production, distribution and supply of goods within the state is part of the state subject. If trade and commerce within the state is part of the state subject, why is Parliament passing the 3 farm laws, which seems to violate the distribution of powers? Does that mean Parliament is wrong? No. Why? Because the government found a way. What is the way? Entry 33 in list 3. What is list 3? List 1 is union list. List 2 is state list. List 3 is concurrent list. What is concurrent list? Both Parliament as well as state legislature can pass a law. What is this law? Entry 33 of list 3, concurrent list, says trade and commerce, production and supply and distribution, products of any industry, if it is in the public interest, Parliament will have the power to make a law. So what is the situation? Yes, trade and commerce within the state, production, supply and distribution of goods within the state, that's within the domain of the state. But if the Parliament wants, some goods, some products can be deemed to be in public importance. And for their public importance, their trade, their commerce, their production, their supply, their distribution, Parliament also has the power to make a law under concurrent list. Which means items such as foodstuff, edible oils, cattle fodder, raw cotton, jute, whatever it is, if these items are declared as for public importance, then their production, their supply, their distribution, their trade, their commerce, even within the state, who has the power to make a law? Parliament, under entry 33 of concurrent list. But do you know there is a history behind entry 33 as well? It was not meant to be in the Constitution in the first place for a long time. This entry was supposed to be there in the Constitution only for 5 years, beginning 1950. So this entry 33 of concurrent list, it was meant to be in the Constitution only for 5 years. Why for 5 years? Because when we got independence, we were poor. But not all states were poor. There were some states which were doing good. We were not self-sufficient in food. When we were not self-sufficient in food, can the Parliament sit mute? Can the central government sit mute and see that there are some states which have enormous food grains? They can even kill their stomach by eating a lot. And there are others who are struggling to have 2-course meals. It is for this reason, because we were not self-sufficient in food, and we thought that we will become self-sufficient in 5 years. That is why for 5 years, from 1950 till 1955, 1950 when the Constitution was enacted, till 1955, we thought that in these 5 years we will become self-sufficient in our food. And for these 5 years, Parliament, although agriculture is a state subject, although trade and commerce is a state subject, although production, supply and distribution of food grains is part of the state subject, but for 5 years, Parliament can also make a law so that from some rich states, this food can be transferred and sold to the smaller states. But what was meant to be for 5 years became permanent forever and ever and ever when a constitutional amendment bill was passed. And that constitutional amendment bill was 3rd Constitutional Amendment Act 1954. So this bill, what it did, it converted a temporary provision which was meant to last only for 5 years. This bill converted this temporary 5-year provision to a permanent feature of the Constitution, wherein today it is a permanent part of the Constitution, where today at any point in time, Parliament can say that there are some food grains for their national interest. We will say trade and commerce, production, supply, distribution of such food grains. Parliament also has the power to make a law. So when the Parliament enacted the 3 farm laws, it was not unconstitutional. Why? Because Parliament does have this power. Why? Because Parliament derives this power from what? From entry 33 of concurrent list. But when this bill, Constitutional 3rd Amendment Act 1954, when this bill was presented before the Parliament, there were some members of the Parliament who objected. They said, don't do that. Why? Ashok Mehta, for example, when emergency was imposed in India, Ashok Mehta was one of the first few leaders who were arrested by Indira Gandhi. And after Janata Party came to power, a committee was set up under Ashok Mehta to study Panchayati Raj institutions. And we will revisit Ashok Mehta on Monday when we will discuss Panchayati Raj institutions. Ashok Mehta basically said and warned the center that if you really want to control trade and commerce in states, then over time what you will also do, you will control crop planning and cultivation. You will say what can be cultivated in a state, what cannot be, because it is in public interest. Parliament can regulate that. And then what you will do, you will encroach into the rights of a state, thereby violating federalism. K.K. Basu basically said, through this amendment, you are converting our federal constitution into a unitary constitution. This is a reactionary legislation introduced as an innocent, innocuous piece of legislation. This is not innocent, you're disturbing federalism. You're snatching the rights of the states to decide what to cultivate, what not to cultivate, how to produce, how to supply, how to distribute, how to conduct trade and commerce within that state. You're destroying federalism. And perhaps the warning of Ashok Mehta, perhaps the warning of K.K. Basu, these warnings ringed when the 3 farm laws were passed in 2020, where the states such as Punjab, Haryana, and the Western UP, when the protesters started protesting and warned that this is the blatant encroachment into the rights of the states. But be that as it may, this is the distribution of legislative subjects, wherein Parliament has the power to make a law on union list, Parliament has the power to make a law on concurrent list as well. And states in normal circumstances have the power to legislate on any item mentioned in the state list. Any questions as of now? Is these 3 bills constitutional or not? These 3 bills then became laws. These laws later on were repealed by the Parliament. So now there is no question of constitutionality or unconstitutionality. Done? Then there is Article 249, which we have discussed previously, but let's repeat. It's a special power given to Rajya Sabha. If Rajya Sabha passes a resolution by 2/3 members present and voting, after this resolution, Parliament can make a law on state list. That means when there is distribution of powers, Parliament has the power to make a law on union list, Parliament has the power to make a law on concurrent list. On state list, in normal circumstances, state legislature passes a law. What are these abnormal circumstances? President's rule, for example. National emergency, for example. But even in normal circumstances, if Rajya Sabha passes a resolution under Article 249, which is passed by 2/3 of the members present and voting, this resolution basically allows the Parliament to make a law on state list. Rajya Sabha represents the states. So if the Parliament wants to legislate on state subject, Rajya Sabha's approval is necessary because Rajya Sabha represents the states. And if Rajya Sabha passes a resolution and then the Parliament enacts a law to make a law on any item mentioned in the state list, what is the validity of that law? That can be asked in your prelims examination. And the validity of such law is 1 year. Extended for another year. Can be extended further, can be extended further, can be extended further for n years. But every time, Rajya Sabha should pass the resolution approving the continuance of this law. For example, if Rajya Sabha passes a resolution by 2/3 of the members present and voting, then what will happen? Parliament is empowered to make a law on a state subject. Which state subject? Which this resolution talks about. What is the state subject? Let's say it can be agriculture. The solution to passing the 3 farm laws should have been Rajya Sabha should pass a resolution by 2/3 of the members present and voting, and then allow the Parliament, you make a law on state list, which is agriculture. But then the problem is that this law will be valid for only 1 year. Can it be extended further for another year, 1 year? But Rajya Sabha should give approval again for its continuance. Can it be extended further for another 1 year? but Rajya Sabha should give the approval. So the validity of a law passed by the parliament on state list under Article 249, the validity is 1 year, can be extended for another 1 year, but the approval has to be given by the Rajya Sabha. That is Article 249. Then we have Article 250. During national emergency, we have discussed that Parliament enjoys the power to make a law on state list as well. And we say Parliament enjoys concurrent power on state list during national emergency. What is this concurrent power? That means concurrent. At the same time, concurrent, Parliament also has the power, state legislature has the power. That means during national emergency, is Legislative Assembly of a state dissolved? No. Legislative Assembly continues. When Legislative Assembly continues, that means Legislative Assembly can make a law on law and order, land, agriculture, police, gambling, yes. But since it is under national emergency, Parliament enjoys concurrent power. That means you can say all the items mentioned in the state list during national emergency, they are as if they are part of concurrent list, because Parliament also has the power to make a law. Listen to me carefully. If I say during national emergency, Parliament alone has the power to make a law on state list, this statement is wrong. Parliament also, that means concurrently, along with the state legislature, can make a law on state list. That is why we say during national emergency, Parliament enjoys concurrent power, because Legislative Assembly is not dissolved, it continues. It can also make a law on state list, but Parliament also enjoys power to make a law on state list, which means this state list is now a concurrent list during national emergency. And this law which is passed during national emergency, for how long will this law continue? This law passed during national emergency continues during the period of national emergency, which means national emergency is in place. This law which is passed during national emergency, it also continues. National emergency continues, this law continues. National emergency is revoked today. This law will continue for a further 6 months, after which it lapses. That means during national emergency, when Parliament makes a law on state list, this law continues till the time national emergency is in place. But if the national emergency is revoked today, this law will continue for a further period of 6 months. After 6 months, this law lapses, it will not remain in force, because then national emergency is over. Now state legislature is in the normal circumstance. Now state legislature alone can make a law on state list. Is that clear? Done. So now that is it for today. We had the class from 7 to 10. We will meet on Monday. And Monday we will discuss Article 252, Article 253. We discuss remaining legislative relations, remaining administrative relations. Then we will discuss federalism. Then we will initiate a discussion on local government. We will look at Panchayati Raj and municipalities. Analysis, whether 73rd and 74th Amendment is doing good or bad, we will discuss on Tuesday. So Tuesday first half, we will discuss 73rd and 74th Amendment analysis of it. And then we will initiate a discussion on judiciary. So on Tuesday, Wednesday, and Thursday first half, we will discuss judiciary. Then Thursday second half, elections. Friday, elections. Monday, elections. And Monday, sayonara. Okay? It's amazing how time flies by so quickly when I'm in your class. Normally, I would feel like I've been studying for 2 hours, only to find out that it has been couple of minutes. However, in your class, I'm pleasantly surprised to realize the 3 hour has already passed. Thank you so much. Thank you. The house is adjourned. We will meet Monday, 6 o'clock in the morning. Till then, have a great time. Bye-bye. Stay safe. Stay well. And if you want to attend my class again, then join me on our YouTube channel today, 8 o'clock, and we will discuss polity this week. See you on YouTube. If not there, see you here on Monday at 6 o'clock. Bye-bye. Take care. Stay safe.